May I please, Your Lordship? Lordship, I beg to mention item number 25 of today's list. I've taken the consent of the other side as well. Matter may be adjourned for the day today. I've been led by Mr. P.K. Tiwari.
24,
25.
25. You taken consent?
Yes, I've taken the consent of the other side.
List after answering vacation as paid for by Mr. Ajay Das, counsel for the petitioner.
Deeply obliged.
May I please, my lordship? May I beg to mention item number 8 as I beg to mention item number 8 as my
8.
senior counsel is not present due to some personal difficulty. Can this matter be fixed on Friday, my lordship?
Friday? Absolutely no. And this I can accommodate till day after tomorrow.
Lordship, there is some election process.
Friday I'm not taking up this
Then
matter.
can
At
this
no
matter
cost.
be after vacation?
After vacation is okay.
Much
List after answering some vacation as paid for by Learned Counsel for the petitioner.
May it please, my lord. Item number 45, my lord. State has filed their affidavit in opposition, my lord. We need some time to file our reply, my lord. 45. It may come up after vacation, my lord.
List after answering some vacation to enable the Learned Counsel for the petitioner to file affidavit in reply in the matter.
Obliged, my lord.
May I please, my lord? Item number 56, 57, and 50, 56, 57, and 58 of supplementary list, my lord. We have filed our affidavit, my lord. That may be called for, my lord. Deeply obliged.
May please, I have some urgency when I let it be taken up Wednesday, my lord. Admission. It's not admission. Admission.
Admission, what is the agency?
My lord,
If you are going for a hearing, then we are not taking up hearing.
Well,
Hearing will take up old matters first and then we'll come to new matters.
admission, my lord, not a hearing, my lord. It's possible, my lord. Lordship, like,
No, please be sure because we are not taking up hearing matters.
no, hearing, not hearing. Admission, my lord.
Okay.
Public.
May I please, lordship? I beg to mention item number 35 lordship of daily list. Lordship. 35. Which may be listed lordship after vacation lordship.
35.
35.
List after answering some vacation as paid for by Learned Counsel for the petitioner.
Yes.
I beg your lordship permission on listing of one read petition, my lord, in admission on Wednesday or Friday, my lord.
Admission, we are not taking up. If you are going for a disposal, then we are not taking up for disposal.
My lord.
We'll take up all hearing matters first instead of
No, my lord.
make it after vacation.
My lord.
Lordship, I beg to pay for listing of this motion, your lordship, for on 26th, your lordship, Wednesday. Pay for listing of motion matters for listing
Motion,
of lordship.
The admission matter, my lord, it was fixed on 8/5.
Admission, we are not taking up hearing. But if you want a disposal, we are not taking it up. If you want a rule to be issued, welcome. Then we don't even need the file. I'll admit it right now.
Item 41 of today's daily list, my lord. I'm praying for having it after the vacation.
I did not hear you.
Item 41 of today's
41.
daily list. Notice has not been issued, but I'm not in communication with the petitioners. I may be permitted to communicate with them. This might be taken after vacation.
And after vacation.
After vacation.
41. List after answering some vacation as paid for by Learned Counsel for the applicant. Why does is it a tied up matter before this bench?
Well, because the lordship had passed an order, my lords, that we had filed an RSA, my lord. Instead of the RSA, the order 43 rule 1 first appeal would be maintainable because we were given the liberty to refile. In between, my lord, the COVID period intervened and there was some difficulty in that, my lord. So whether it should be pursued at all or not, my lord, I have to take that instruction.
Okay.
Please, lordship. Lordship, I beg to mention one read petition for listing it under admission calendar, lordship.
Admission, we are admitting it right now. We don't even need the file.
Lordship, there is an
You want us
urgency.
to issue rule?
Yes, your lordship.
Issue rule. Just get it. We'll get the records. Supplementary hearing, the supplementary list. We are passing the orders right now. The both sides are represented. Issue rule, returnable forthwith without requiring the petitioner to take steps.
Listing.
Understand. But listing will not fix and we'll take it up today and we'll issue rule.
Then after vacation, your lordship.
না না আজই কেন হবো আপনার প্রোডাকশনও দেখেন লিকুইডিটি
Admission, I am issuing rule.
Okay, your lordship.
So you give it, we'll pass orders.
Your lordship. Yeah, please, your lordship. Lordship, I got to mention item number 13.
13.
Yes, your lordship. Lordship may not like to take up this matter.
Oh, this is not before me. Item 13. This matter before any other bench without me.
Listing of an IA, your lordship, on 26th
What is the IA for?
for some typographical error, your lordship.
Make it tomorrow.
Yes, your lordship. Oblique.
Please, your lordship, lordship, item number 50 to 55. Lordship, it relates to non-payment of salaries of teachers in provincialized schools. Really, it's a civil bench 2 matter, lordship. It's a civil bench 2 matter, lordship.
52 to
And
55.
it may be relisted.
আইটেম নাম্বার
50 to 55. Hearing.
Okay. 50 to 55. Both sides are represented. The land counsel for the petitioner has submitted that the matter relates to bench 2. The registry shall examine and raise the matter before the appropriate bench.
Maybe a date may be fixed, lordship. Date may be fixed, lordship. They haven't
They will
received their
do it.
salaries.
They will do it. The registry will do it.
Actually,
Yeah, please. So I am paying for withdrawal of a case on tomorrow. Obliged.
আইটেম নাম্বার 1 ফর মোশন কি খাটো লেগে উঠাই দিই 7
After the, you know.
concluding of
Yes.
Well, last year also petitioner council was not there, my lord.
But this is area leave salary, even if
Yes.
they are not there.
Yes, my lord. I
But
have
what is your instructions?
I have instruction. Proposal has already been sent, my lord. It is in process, my lord.
None appears on call for the petitioner. Mr. S. Datta, Learned Standing Counsel for the PNRD department, has produced a copy of instructions dated 14/6/2024 to indicate that
9 লাখ আপনার বলে
the budget for a proposal for budget for sanction of rupees 76,311 has been raised raised in respect to the area leave salary of the petitioner. The sanction of the said amount is awaited. In that view of the matter, the In view of this, in view of such instructions, come on. The matter stands adjourned today. We hope that the respondent shall do the needful by the next date of listing, or a list after 4 weeks. The instructions produced are retained in the report.
Obliged.
Yes, item 2.
Item 2 for motion.
Appears that the name of the learned counsel for the petitioner is not reflected in the cause list. According to the registry, shall reflect the name of the learned counsel for the petitioner in the cause list while listing the matter next para. Contempt petition. Order dated 15/11/2023, passed in WBC 1132 of 2023. Notice steps within a week. Pendency shall not be above. Give a date after.
Item 3,
Give a date after 5 weeks.
5 weeks. 19/8.
Please, Your Lordship. But hearing this case on 1/3/24. The Honorable Court was directed to take instruction to the respondent.
Lordship, I have not got the written instruction, Lordship, but I've got the oral instructions. May I place them, Lordship?
Yes.
What has happened is that in this case, Your Lordship, initially there was some complaint, so that's why the process was stopped. But what is going on right now is that, Your Lordship, there is an amalgamation of Anganwadi centers going on throughout Assam, Your Lordship. Because of that, not only this process of selection, but entire thing, in their case, it has been postponed. In other cases where they have not been postponed, but in fact the interview has gone on and even the select list, etc., has come out, Your Lordship. Even there, the process after that, no appointment has been done, Your Lordship, because if the centers are merged together, then obviously if one person has got selection there, appointment there, then it is merged with another one, then this will create a further Pandora's box, Your Lordship. So, Your Lordship, what has happened is that not only this, but other interview processes are also as of now stalled because of this reason, Your Lordship. So it will take
Issue a notice in the meantime you file your affidavit.
Lordship.
Mr. Ghosh, it can't be held then.
My lord, here in this case, objection which was raised earlier, for which the interview was not held, that was also taken care of when the second time interview was called for. Kindly see page 50, my lord. That part has taken care of. That except these 3 controversial center, other interview may proceed. Page 15.
No, Mr. Hazarika is saying that the entire process is being revamped.
But my instruction is that this was only postponed. Interview was postponed. In all
That's
other
okay.
cases, interview was held.
It's okay, we're issuing a notice. That's fine. But Mr. S.K. Ghosh, learned counsel for the petitioner, as well as Mr. C.S. Hazarika, the government advocate.
All
Appearing
the
for the respondents. Next para. The learned government advocate has committed that on the last date when the matter was listed on 1/3/2024, he was directed to obtain instructions as per his verbal instructions, process has been taken up by the appropriate government for amalgamation of a few Anganwadi centers. Therefore, as per his instructions, the present
Item 24.
process of appointment has been put on hold. Be that as it may, issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the government advocate in course of the day. List after 4 weeks. You also make notice, including notice on the prayer for interim relief.
Item 4,
This matter relating to suspension from service lawsuit. The only issues. Well, the only issue is that the order has not been reviewed even after the expiry of 90 days lawsuit. And law is settled in that regard is that lawsuit, it is mandatory on their part to review the order lawsuit after expiry of 30 days, 90 days. Well, as held in the case of Ajay Chaudhary as well as Rekibuddin lawsuit. Division bench judgment of this honorable court also. Well, suspension was made on 8/8/2023 lawsuit pace and
Yes,
21.
departmental proceeding has started, no.
Yes, my lord, within 60 days, my lord, charges have been framed, my lord. My lord, identical case, my lord, is disposed of last Friday. No. Just let him complete, my lord, then I will show my from the affidavit, my lord. My lord, the honorable Supreme Court in the case of lordship Ajay Chaudhary, if your lordship, I am giving that lordship. Paragraph 21. It is clearly held that like, even a charge is framed, charge sheet is given. It is mandatory on their part lordship to review the order.
Can you read the next paragraph?
My lord.
Can you read the next paragraph?
My- Next, 22. So far as the facts of the present case are concerned, the appellant has now been served with charge sheet, and therefore this direction may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continued suspension in any manner known to law, and this action of the respondent will subject to judicial review.
Even Supreme Court did not know if there was any other way to challenge this, so it has left it open.
My lord, in
Can't be.
paragraph 21,
Para 21 is 22 excludes 21.
my lord, continuation of the suspension order that can be made under judicial review as per lordship paragraph 21, 22 is concerned. My lord, relying this judgment lordship, our high court lordship in various cases lordship, in those cases lordship, I also appear. In that case lordship, suspension order has been set aside and the petitioner was directed to read lordship. My lord, in Haridas case, your lordship may kindly take up first. In Haridas case, lordship paragraph 7.
Which case?
Paragraph 7, lordship page 5.
No, which case?
In Haridas case, lordship 312423, lordship.
Yes.
My lord, further transfer that the petitioner was suspended right and order so and so in terms of rule so and so. The petitioner was granted bail so and so. A plea and this as a matter was duly brought to the content attention of this appointing authority and so and so. In recent judgment by this court on dated so and so in case of Rafet Ali Ahmed versus reported in WBC so and so, this court held that another condition has to be called out on the basis of the law laid down in the case of Ajay Chaudhary as well as in case of Rakibuddin Ahmed Supra to the effect that when the memorandum of charge sheet is not served upon the delinquent employee within 3 months from the date of release on bail or release from any custody or imprisonment. And if the memorandum of charges charge sheet is served, a reason order must be passed for extension of suspension. It was also mentioned that the period for applying the said condition shall be taken up for consideration by the appointing authority when the delinquent officer employed brings the fact that he has been released on bail or otherwise not in custody, in any custody or imprisonment to the appointing authority who has the power to vacate the suspension order. Paragraph 17 to 20 of the said Rafet Ali judgment version is quoted below. And the lawship, relevant lawship, paragraph 8. In the instance case, it would be seen that the appointing authority on 7/9/2022 issued the suspension order on the ground that the petitioner was arrested on so and so by applying rule so and so. Thereupon, on 31/10/22, the petitioner was released on bail, which was brought to the attention of the appointing authority on so and so. Under such circumstances, applying of law laid down in case of Rafet Ali Supra, the respondent authority having not served the memorandum of charge sheet upon the petitioner could not have continued to place the petitioner under suspension after the lapse of 3 months from the date of due intimation. Considering the above, the court direct the respondent authority to forthwith reinstate the petitioner upon a certified copy of the instant order being served upon that. Now, here in this case, lawship, charge sheet was not served, but in our case, charge sheet was as served, and we have given reply lawship. In fact, the inquiry has already been completed and inquiry report also furnished, and we also filed our reply. But no final order has been passed till date, lawship. And in Rafet Ali case, lawship, I have given paragraph 15 and 20, your lordship may kindly see. Paragraph 15 and 20. Well, 20 is important, lordship. Page 13, your lordship may. Page 13, last part, lordship. However, upon applying the judgment of the Honorable Supreme Court in the case of Ajay Kumar Chaudhary and the judgment of the division bench of this court in the case of Rakibuddin Ahmed, a fourth condition can be carved out. That is where the memorandum of charges charge sheet is not served upon the delinquent employee within 3 months from the date of release on his bail or release from any custody or imprisonment. And if the memorandum of charge sheet is served, a reason order must be passed for the extension of suspension. Now the question therefore arises when the above condition can be taken into consideration by the appointing authority. In the opinion of this court, condition above noted can only be taken into consideration when the delinquent officer employee bring the fact that he has been released on bail or otherwise not in any custody or imprisonment to the appointing authority who has the power to vacate the suspension order. My lord, we have duly intimated the authority by filing an application lawsuit. And in view of this lawsuit, this honorable court has interfered with the order of suspension lawsuit. In another case, Abdul Baki Sheikh lawsuit I have given. But in Paki Sheikh case, Lordship, another case, 4119/2023, Lordship. Case 2, Lordship, last paragraph. But relying those judgment, Lordship, this honorable court, Lordship, again interfere with another suspension order. Case 3, Lordship, just before the last paragraph, conclusion part. After consideration of the rival submission, this court is of the view that the point involved is no longer res integra in view of the ratio laid down by the honorable division benches in case of Rakibuddin Ahmed, whereby it has been held that the requirement of a review of a suspension order has to be followed even in case of deemed suspension. In that view of the matter, this court is of the unhesitating opinion that the present order of suspension is unsustainable in law. Accordingly, the same is set aside.
My lord will find all the cases that my friend has relied upon. In every cases, my lord, charge sheet was not filed within 90 days. That is prima facie, my lord. Here is a case, my lord. My lord will find he was arrested on 7/8/23. Dates are very important, my lord. 7/8/23. His suspension order was passed on 8/8/23. And my lord, charges was framed by show cause, that is 131/10/23. So that is within a, my lord, limitation of 70 days. It was done. And my lord, inquiry continued. He has charge sheet on, my lord, 31/10/23. We have stated in para 7. 31/10/23. He joined, my lord, and he then so, my lord, now, my lord, if you go by Ajay Chaudhary para 22, my lord, that will culminate into, my lord, that once the charge is framed, my lord, it goes even beyond 90 days even. Ajay Chaudhary, my lord, the irony of the case in Ajay Chaudhary is that, my lord, so many people got benefit out of the Ajay Chaudhary, my lord, but Ajay Chaudhary never got any benefit out of this order, my lord. Only because that after a span of prolonged, my lord, few years, my lord, that charges were framed. That is why he did not get, my lord, himself, my lord, any benefit out of that order. In a similar footing, my lord, but here we have done it before 90 days. So, my lord, so what my friend has, my lord, cited, my lord, these cases are not in the similar footing, my lord. That is what my humble submission, my lord, if your lordship.
My lord, in Rakibuddin case, Lordship, division bench judgment, Lordship. In Rakibuddin case, Lordship, the honorable court has mandated that it is a mandatory on their part to review even after Lordship charge sheet is filed. And reason order is to be passed. Paragraph, Lordship, 15, 16, and 17. Reported in, Lordship, 2022 GLR 621. 2020 2 GLR 621.
Item 5.
May I please? So this is the matter pertains to conditional ground. Here the father of the petitioner died on 1/5/2013, and the petitioner applied for completion appointment on 13/6/2013. Thereafter, the DLC has recommended the name of the petitioner along with the two other candidates from the establishment. And the SLC has rejected the name of the petitioner only on the ground that the name of the petitioner does not fall under 5% characteristic. Here the page number 19, that is the minutes of the DLC. And relevant portion is page 21. Page number 21, serial number 18. May I read, madam? 3 proposal received from the EEPHA Shivsagar division for the post of junior assistant grade 3 in respect of Sri Sujay Kumar Bora, Sri Lohit Gogoi, and Sri Triloko Deuri, that is petitioner, were found eligible for consideration against one number of vacancy for the year 2013-14. And Sri Sujay Kumar Bora has fewer landed properties than other 2 applicants with 3 dependents. Thereafter, the minutes of the SLC is page number 26. Here, the grounds is page number 29 is the relevant portion, page number 29. SLC has rejected the following candidates on the grounds. Here, serial number 3, Sri Triloko Deuri. Here, the name of the petitioner has already recommended by the DLC against one post. Now, how SLC rejected the name of the petitioner along with the 2 other candidates? After again, I have submitted a representation before the executive engineer, Shivsagar Division, on 16/11/2021 for reconsideration of the petitioner name for the. And on the last occasion, the Honorable Court has directed me to file additional affidavit to bring on record as and when I have received the SLC minutes, that I have filed, madam. In this case, notice may be go, madam. The DLC said against one post that I have been recommended. Hello. Here, they have not mentioned that 5% vacancy is whether from this year or 2013-14 or in the year of 2020. Madam. Hello. Hello. 5% obstacle. No. This 0.3. But here they have not mentioned the year. That 5% is in which year they have said about the 5%. Milo. It does then means about. Total. Page number 32, is saying that the committee also instructed that in future, the total cadre strength, vacancies as well as vacancies meant for compassionate ground, appointments should be clearly shown for any relevant year, along with the roster point men in position in the cadre number of compassionate appointees in that cadre, etc. There should not be carry forward of vacancies for purpose of the compassionate appointment. Two.
No, Your Worship, respond number 2 only. Mr. Apukan was here for GAD. He was just here, Mr. Apukan, standing council GAD.
The petitioner applied for appointment on compassionate ground on 13/3/2016, which was forwarded to the DLC Sipside Hub. In the DLC meeting held on 27/4/2015, the name of the petitioner was recommended for the post of junior assistant, grade 3, against one number of vacancies for the year 2013-14. First of all, the matter was then taken up by the SLC in its meeting held on 14/5/2020. However, the SLC had rejected the candidature of the petitioner on the ground that the total cadre strength of junior assistant within bracket grade 3 in the establishment of the executive engineer within bracket PHE bracket Sivsagar was 7, and therefore there would be no post under 5% quota for appointment on compassionate ground. But Mr. Bora, even if grade 3 is not there, he can accommodate, he can be, or he could have been considered for grade 4. Any grade 3 or 4 post.
But your lordship, if I may state one more fact, your lordship.
Yes, yes.
Your lordship, this particular case is squarely covered by the Devota Tiwari judgment, because the person he died in the year 2013. Para 7.5 of the Devota Tiwari judgment deals with the case of immediacy. How that immediacy part has to be justified by the petitioner as to how now, if suppose he is considered for a compassionate appointment, how that particular paragraph number 7.5 will be satisfied. And also, this SLC has not been with a party in this particular writ petition. SLC is not a party in this writ petition. And SLC had rejected in the year 2020 itself. And he has approached the your lordship in the year 2024. There also delay of 3 years, because that way immediacy is a prime concern in any compassionate appointment case. Here, that particular requirement is not fulfilled, in my humble submission, your lordship.
The counsel for the petitioner submitted that the rejection of the candidature of the petitioner by the SLC on the ground that the post does not fall under 5% of total cadre strength is arbitrary. It is also submitted that the petitioner belongs to ST within bracket P category, and therefore he is entitled to be considered for appointment under the said category. So accordingly, the counsel for the petitioner submitted that the candidature of the petitioner shall be directed to be reconsidered by the SLC, and his application should not be rejected on the ground that no 5% vacancy exists in respect of the grade 3 post in the establishment of the smaller number And it's not establishment of the
Respondent three.
establishment of the executive engineer PHE, Sivsagar, within bracket respondent number
Three.
3. So the government advocate has opposed the prayer made in the resolution and basis reliance on the decision of the Supreme Court of India in the case of Devrata Tiwari versus State of West Bengal and others.
State of West Bengal versus Devota Tiwari.
Achha, State of West Bengal versus Devrata Tiwari. Next para. From the SLC minutes dated 14/5/2000, it is seen that the grade 3 post of junior assistant in the establishment of the executive engineer PHE Sivsagar division with the respondent number 3 bracket is 7, and therefore the said post far below the the availability of cadasters of 7 in the grade 3 post in the said establishment does not entitle any selection to be made for appointment under compassionate ground as it would require a minimum of 20 cadre strength to have 5%, to have one post earmarked for appointment on compassionate ground under the 5% quota based on cadre strength. Therefore, when the cadre strength is 7, no post will be available for appointment on compassionate ground. Para 7.4 and 7.5 of the case of the Devrata Tiwari, even bracket CEPA is quoted below. Next para. In view of the fact that the father of the petitioner had died in harness on 1/5/2013. By this time, more than 11 years from the date of death of the father has gone by. The candidature of the SLC was the candidature of the petitioner was rejected by the SLC. In its meeting held on 14/5/2020. And in this case, the challenge is made almost after 4 years. Therefore, by the time his repetition is being taken up, the immediacy of the requirement of appointment on compassionate ground is already lost as per the ratio laid down in the case of Devrata Tiwari. Next, under such circumstances, the in view of the principle 10 of the OM dated 1/6/2015, which requires that applications which cannot be considered due to want of vacancies for a period of 2 years from the date of making such application, comma, all such applications require no further consideration. To stop. Accordingly, this regulation fails and the same is dismissed.
But that page number 33, I have submitted representation before the executive engineer. That will be recorded madam, on 16/11/2021. Page 33.
It's come after 4 years. At this stage, the land council for the petitioner submitted that a representation has been submitted by the petitioner before the
Executive engineer PHC,
executive engineer, PhD, then packet respondent 3 on
16/11/2021.
16/11/2021. Okay. Item 6.
Where please, your lordship. My lord, this is the second round. Kindly see page 52, my lord. Page 52. The petitioner who are all paragraph 2, serving as a state assistant in the social welfare department are agreed to the extent that the gradation is dated 31/5/2022 issued from the office of the director social welfare department. The name of the respondent of the petitioner number 1 and 3 were wrongly shown in order of seniority, whereas in respect of petitioner number 2, the name has been omitted from such list. Raising the said grievance, the writ petitioner is instituted. Another grievance, this is the main grievance actually. Another grievance of the writ petitioner is in respect of respondent number 5, whose appointment was delayed at the initial stage, had given notional fixation of seniority and salary. It is stated that the present petitioners are also similarly situated, wherein their appointments were also delayed, but the similar benefit of notional seniority and salary that had been given to the respondent number 5 were not given to the writ petitioners. So, then next page, paragraph 5. In the individual representation, the petitioner are also raised the claim that respondent number 5, certain notional benefit of seniority and salary had been given in as much as there was a delay in his initial appointment, whereas the case of the petitioner also, who were also similarly situated, no such notional benefit had been given to them. If the notional benefit would have been given to the petitioner, in such event, their position in the merit list would have been varied accordingly. This part was fresh representation we have submitted pursuant to direction, and the impugned order, my lord, at page 55. On 26/12/2023, it was rejected without showing any reason, nothing, my lord. Page 57. Is
Yeah,
this-
just a moment.
Yes.
Yes, Mr. Vora, he is entitled to notice.
Yes, Lord. Notice may go ahead.
So see, if he's from the same list, then he'll be entitled to be considered from that day.
Lordship, let us see what the department has to say.
But Mr. S. K. Ghosh and transfer for the petitioners, and Mr. D. Balaran and government advocate appearing for the all the respondents. The where is the gradation list?
Gradation list, my lord, at page 40. 40. Annexure A.
Where is your serial number?
Serial number 153. Page 153, page 44. One 55 and 156.
155 and
153, Manoj Kumar Rai.
and 155.
Petitioner. Yes,
Now you are claiming your position to be should be where?
102. 106, my lord, Sanjit Das.
106.
106. He was in the serial number 9 in the merit list.
But then we'll have to also pose a question of maintainability of your reputation. The people who will be affected by your changing your in the serial team, they are not parties here.
All
No, whoever will be affected with the change in the seniority position, they are not parties here.
in earlier round, we made party to Sanjit Das.
No, I don't know, but since they are not here, we are issuing also we are questioning the maintainability also. The petitioners claim that their selection is relatable to the where is the earlier appointment order?
Our appointment order.
No, the list first list prepared.
Prepared.
Where is that? The
At page annexure 2,
page
page 20.
20. This slip list to which the appointment of the petitioner is relatable to is the notification which was published in the Assam Tribune on 11/2/2006. And accordingly, it is claimed that although the petitioners were appointed on 29/6/2013, but they would be entitled to retrospective seniority and notional pay on from
105,
on and from
because one,
2006. Stop. The Learned Counsel for the petitioner has submitted that that in the seniority list, which was published, sorry, provisional gradation list which was published by the Office of the Director of Social Welfare Assam on 31/5/2022. The altered position of the petitioners would be from
kindly see 105.
serial number
105, benefit of given to him
no, now your position would be how much?
after 105.
After serial number 105. Full stop. If you notice on the notice including notice on the prayer for interim relief. Oh, sorry, it will be question of motion returnable on in 4 weeks. Full stop. In view of the fact that persons whose names in the provisional gradation list would be affected by the prayer made in this declaration on our parties, the petitioner shall also address the court on the Learned Counsel for the petitioners shall address the court on the maintainability of the petition on the next date of listing. Next para. List after 4 weeks. This gradation list,
Well, it
you
is
know,
a
you have to not finalize it.
Yes, it is a provisional gradation list. So I raised the objection before the department, my lord.
The provisional gradation list dated 31/5/2022 shall not be finalized till the disposal of the petition. No, department objection is okay, but for the court to disturb the serial time.
No,
Yes,
since
that is the court.
it has not been finalized.
No, that's okay.
If
But
it
for
is,
the
it
court
would,
to do it,
Your Lordship,
we have to make notice.
Your Lordship, if the parties, if the incumbents of the serial number from 105 onwards, if they made a party, then they would be in a better position, Your Lordship.
Let us issue that notice.
Let
Item
them,
7.
let them implement them also, Your Lordship.
Item 7.
Well, in this case, my lord, I must be some civil appear, my lord, for time being, my lord.
We'll record our presence. This is only you were dismissed by the
My lord?
the petitioner were dismissed.
Yes, ma'am.
We issuing notice, we'll record our presence.
Yes, ma'am.
You are
I Rafiq. I Rafiq. I Rafiq. I Rafiq.
Mr. I Rafiq, Learned Counsel for the petitioner. Also heard Ms. B Sharma.
B, sir, MS, B, sir.
Ms. B Sharma and CEC appearing for the respondents. Next one. Agreed by the termination of service of the petitioner by order dated 2/3/2024 is under challenge in this writ petition. You have not filed a departmental appeal.
No, my lord.
Then you have alternative remedy. Why we should entertain the
Yes,
writ
sir.
petition?
Because, my lord, it violates the natural justice, and moreover, the inquiry officer who has conducted the inquiry, my lord, is not competent, my lord, as per the procedure. There are two grounds, my lord. And I have already filed another petition, my lord, challenging the appointment of the inquiry officer that is pending. 59. Page 59, annexus 6. Relevant portion is at page 61.
Where is the order?
My lord,
59 pages.
relevant portion is at page 61.
61.
What is the ground of challenging the inquiry officer?
Because, my lord, the person, my lord, who was appointed below the rank of the fact-finding officer, my lord, which is not permissible.
The rank of?
Below rank of the fact-finding officer.
Who was the fact finding officer?
Fact-finding officer is the page, my lord. One inspector, my lord. And fact-finding officer, my lord,
ESC is Assistant Security Commissioner.
yes, my lord.
He is higher in rank.
Yeah, he is higher in rank, but the
Then-
person who was appointed is inspector. My lord. The person who was appointed as the inquiry officer is an inspector, my lord.
So you want the inquiry officer to be higher than?
Higher than the fact-finding. There is a guideline in this regard, sir. And it is under challenge.
No, no, inquiry, someone higher than Assistant Security Officer was the inquiry officer.
It
Can't
should
be.
be, it should be.
Close the document.
My lord, all those documents I have submitted in the other writ petition.
Fact finding is higher than Assistant Security Officer.
Fact-finding officer should be higher than the inquiry officer, who has been appointed as the inquiry officer to conduct the inquiry.
Can't be.
Well,
Under which rule?
Madam, there is a, let both the matters be listed together, my lord. I have annexed all those documents here.
No, there must be some rule to say that.
There is a guideline, my lord, in the other petition I have annexed. May I read, my lord, though it
Yes.
is not before your lordship. A point has been raised. Authority who has acted as member of chairman of the facts finding inquiry should not be act as disciplinary authority. A point has been raised whether an authority who has functioned as a member or chairman of the fact-finding accident inquiry committee can function as a disciplinary authority for the purpose of considering the explanation to the charge sheet, ordering a departmental inquiry, holding a departmental inquiry itself, or imposing the penalty within its own power. The matter has been considered in consultation with the Ministry of Law and has been held that if an officer, while functioning as chairman or member of the fact-finding committee, has already come to the conclusion and made recommendation that a particular railway servant is guilty, it would be difficult to expect him to approach the case with an open mind. Even more, the railway servant would apprehend that the officer, having expressed an earlier opinion, would not, as a disciplinary authority, depart of his
No,
own.
let come with that record
Yes,
because I'm
yes.
not satisfied. Well, because of the alternative remedy available. That is number one.
Moreover, my lord, the inquiry was held ex parte. I met an accident. I
No,
have
that also
submitted
you can,
representation.
you can assail in the appeal.
Yes.
But when we are exercising extraordinary jurisdiction, you have to tell us how we stand. The another thing is that you have shown us the earlier order of the court. It says any constitutional order will be subject to order of that writ petition.
Yes.
So this will be covered. This writ petition is unnecessary.
Both the
This
matter
court
may be
made an
discussed.
observation that any other orders would be subject to outcome of the writ petition. Then you'll have to either wait for it and withdraw this writ petition, or you'll have to.
Both the matter may be come up together.
Okay. List on day after tomorrow, Wednesday, list on so along with record of WBC
141 to 24.
141 of 2022.
24.
24, okay.
All I think.
Item 9.
This is my second writ petition on the same subject matter.
First order, my lordship, first writ petition. Annexure 4, page 21 may be seen, my lord.
Okay, I should notice here. Heard Mr. S.B. Laskar and counsel for the petitioner. And Mrs. R. Devi Leonard, CEC appearing for the respondents. Next paragraph. Claiming entitlement for pensionary benefit as unmarried daughter of her deceased father who died on 10/7/2020. The present petition has been filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the London CEC in course of the day. Next paragraph, the pendency of the writ petition shall not be a bar for the, who's the authority?
My lordship, the authority is respondent number 4, my lordship.
No, pension will not be given by director of Senate welfare.
2, my lordship. Yes, my lordship. Respondent control.
Respond number
2, my lord.
Respond number 2 to examine the claim of the petitioner and pass appropriate orders.
Item 10.
Matter may be passable for timing.
Yes, ma'am.
Removal from service, my lord.
Mr. Mohanty was there,
Yes.
Mr. T.J. Mohanty, and
No, sir. I'm Datta.
Mr. M. Datta.
I'm Datta.
Okay, your name?
J. Mohan.
J. Mohanty, by Mr. J. Mohanty and counsel for the petitioner, as well as Mr. S. K. Medil and CEC appearing for the respondents. Next, agreed by the order removal from service by the in course of a departmental proceeding and agreed by the appellate as well as appellate order as well as the order passed by the revision authority. The present date petition has been filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the registration be served on the London State and Department, London CEC in course of the day. Next, list one so and so. Okay.
Item 11.
Wait, Miss Worship, kindly bus out for time being. Senior on desk on profile.
Let's start.
ले रहा है
Okay. Sometime.
12.
The petitioner before your lordship has applied for various posts pursuant to the advertisement dated 21/7/2018 issued by the Staff Selection Commission, your lordship.
Yes.
Your lordship, we have appeared in all the examinations, including the physical standard test, your lordship. Otherwise, the petitioner belongs to the reserved category.
It's 2018. Why should we interfere now after 6 years?
Otherwise, the results were declared in the year 2021, your lordship. And in fact, there are judgments of the coordinate bench of this honorable court, your lordship. I have already annexed annexure 6, your lordship. Those were passed in the year 2023, your lordship.
What are your marks and what is the last marks for the secured candidate?
The petitioner, he has scored, your lordship, annexure 5, page 59, 45.53122, your
Page
page 59, annexure 5.
59.
From below, you'll also see the third column. Final score, it's 45.53122, your lordship.
Yes.
And if your lordship kindly come to page 58, your lordship. Which is the results, your lordship. From below, it's 1, 2, 3, 4, 5, 6, sixth column from below, your lordship. Here it is 45.44250, your lordship. Your Lordship, kindly take up page 52, Your Lordship, annexure 3. That is the physical standard test, Your Lordship. Here the petitioner's height is 167
No,
centimeters.
how do you know that what is the last appointed candidate was having how much percentage?
Page 57 is the cutoff details, Your Lordship.
57.
Yes, Your Lordship. Category-wise details of vacancy, numbers of candidates selected, and cutoff details of the last selected candidates male, Your Lordship.
Now tell us where can you be placed? You're under which category? General, Naxal or border?
Lordship, otherwise he's belongs from the reserve category, from the ST category.
No. You are a candidate first out of 3 range. You are a candidate of which range? It is G is general, N is Naxal, B is border. Then we'll have this reservations.
General category G, Your Lordship.
G.
Yes, Your Lordship.
So G, you see in the unreserved category, highest marks is lowest marks is cutoff marks is 98.62. You secured 43, so you will not be here. In G, you won't be placed.
Lordship.
Because the case you have cited is of unreserved reserve category,
Yes,
who scored higher than the reserve category, and therefore the court says that he will be entitled to
Lordship.
by treating him as reserve candidate.
Yes.
Now you will have to demonstrate that you fall within this category. Assam is 58.
Assam is 58.
A is more than 53. You be prepared, we'll take it up at 2.
Lordship. Raise Lordship, day after tomorrow, if the Lordship permits.
Okay. List on. Yeah, tomorrow is 26. 24 for the council for petitioner. Is as Barwan and CGC is present. Obliged.
14.
Lordship, may I pray for a Passover for a time being?
Lordship, I am on the line.
Oh, yes. How much time?
10 minutes, 10-15 minutes. Your Lordship.
No, because AG is, you have to tell him. You
10
don't
to
want
15
to.
minutes. Your Lordship. 10 to 15 minutes. Your Lordship. 10 to 15
10
minutes.
to 15 minutes. Okay. If they get 10 to 15 minutes, he wants.
Yes,
to-
Lordship. No difficulty, Lordship.
Take a break and come back.
2021, the petitioner was suspended pursuant to an arrest in a criminal case. Thereafter, a DP was initiated, which was closed. He was also released from jail and he was reinstated in service. Now, we have come here to, he has not been paid his services for that period has not been regularized. We have also made representations. Lordship, there is only.
The counsel for the petitioner also had Mr. A. Chakravarti, and a government advocate appearing for all the respondents.
Lordship, all the respondents. Only respondent 3 Lordship, so only respondent number 3 Lordship.
Respondent 3. Who's for others?
There is a finance Lordship, made a party, director of accounts, treasury Lordship, and treasury officer Nagaon Lordship. My friends will appear.
Okay, Mr. A. Chaliat, and the standing counsel for the finance department appearing for respondent number 1,
2 and 4 Lordship.
1, 2, and
4.
4. Security for 3. Agreed by non-payment of the balance arrear amount for the period accumulated for the period from 16/9/2021 to 35/2022, and non-regularization of the period of suspension from for the said period is held by the petitioner filing this writ petition under Article 226 of the Constitution of India. Issue notice, returnable in 4 weeks. Requisite extra copies of the writ petition be served on the net State and Department Council in course of the day. That's fine. The pendency of the writ petition shall not be a bar for the, who will be the competent respondent?
Three Lords.
For the respondent to examine the grievance of the petitioner and pass appropriate orders.
Deeply. Public.
Sixteen.
Issue notice. Mr. J. A. Paul, and counsel for the petitioner, as well as Mr. C. S. Zerika, and government advocate appearing for the
Lordship, respondent number 1, 3, and 4.
for the respondent numbers 1,
3 and 4.
3, and 4.
MACT, this FT, they have their own standing council, I believe. Your Lordship.
My lord,
FT.
FT, he can appear with regard to FT matters, only with regard to declaration of foreigners matters, FT council is competent. But with regard to administrative matters, government advocate is also can appear.
So,
Because on last occasion, government advocate deals with the matter while I was suspended.
Maybe
Because
on
these
that
are-
case,
these are
otherwise that
administrative
notice go on, either he can serve on a standing council or else notice may go, Lordship.
No, he's otherwise right. FT matters in the court, they have a standing counsel. But otherwise, government advocate can appear.
Yeah,
This
these
is
are
this is
administrative
service matter.
Otherwise, I've seen, okay, Lordship.
For the respondents. That's correct. The dismissal of service of the petitioner by order dated
1/6/22,
1/6/2022
issued by the respondent number 2.
passed by the respondent number 2 and the dismissal of the departmental appeal where is the order? Departmental appeal?
Departmental lordship will find that
Dismissal of departmental appeal by order dated 6/4/2024 passed by the
here been two important orders.
order number 1
Yes, Alexa 12.
is assailed by the petitioner by filing this writ petition under Article 226 of the Constitution of India. No, something is wrong. Something is wrong. Where is the impugn order?
Impugn order, one, your lordship will find it, Alexa 10, page 57. And another one is page 67 to 70. Alexa 10 and 12, two impugned.
Page.
First input is page 57.
Second,
Second is page 67 to 70.
take it up after vacation. You may, in the meantime, you correct the cost title. The secretary, the appellate authority is not even a party here in the writ
Yes, sir,
petition.
my lord. Respondent number 1.
He is
Commissioner.
the
and Secretary.
commissioner.
Yes,
Appellate order is not passed by the commissioner. That's why I'm asking you.
yes, secretary, commissioner and secretary both are in same
I don't
capacity.
know.
Same capacity dealing the cases.
I don't
Someone,
know.
because
Commissioner and secretary is same. I don't know.
he may,
Add full lock at a if he adds one party, that will be whether it's same or not.
But I don't know. I don't have personal knowledge. In your cost title, the parties,
lordship may kindly go through the second impugn order, page 67.
I've seen that. That's why that's why I said that something is wrong. I asked for your order. It is passed by the secretary
Yes,
and you have made commissioner a party, commissioner and
but
secretary.
while
Commissioner is not, secretary
lordship-
individually is not even a
lordship
party
may
here.
kindly go through page, order dated 5/2.
Okay, just one. Of keeping the issue of mentality of the reputation open, as the appellate authority is not individually a party in this writ petition. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition is served on a learned state and department, learned government advocate in course of the day.
Kindly wait for a minute. Let me go through, because order dated 5/2, which is also a part of record of this petition. 5/2/24.
Some extra copies of the writ petition in course of the day. Next, list on so and so. You check up, I hardly take time in reading.
My lord.
You keep on reading.
Oh, sorry.
We can only show you, but we can't make you understand.
I understood, but
That is beyond our capacity.
5 February 24.
That is beyond
one
my capacity.
communication was issued by Commissioner.
What you are asking is beyond my capacity. Appellate order is by secretary.
Yes,
I don't find secretary a party here. I find commissioner and secretary is a party. Whether they are same or not, I don't know. I don't have personal knowledge. I don't visit,
London
I
Bank
don't
verified.
visit Secretariat, I don't go office by office, looking
No,
at the
I am
nameplate,
not saying-
coming back.
My
That I don't
learned friend
do.
may clarify it.
He will clarify to us. We have kept the issue of maintainability open. You clarify. We have done it.
Item 17.
Yes.
Instead, I am paying for only my notice, my lord. Okay. Appellate authority is here, my lord, Godulan, director, my lord, I am mediating party. My lord.
You are only against the imposition of penalty.
Penalty, my lord, because in the meantime, in criminal case, same charge, my lord, I go take with it, my lord.
Okay.
That is it.
But Mr. T.J. Mathur on a senior counsel, assisted by Ms. P. Bhattacharya and counsel for the petitioner. Also heard
H. Purva on behalf of
Okay.
H. Chaudhary.
H. Barua. You're appearing on behalf of?
B. Chaudhary, standing counsel,
So
BTC.
Mr. B. Chaudhary, Learned Standing Counsel for the Agriculture Department, representing respondent numbers 1, 4.
1 and 4, let's say.
My lord, one is government state of Assam,
Agriculture.
1 and 4, my lord, government.
No, one is Bikram Chaudhary, Agriculture Department.
No, my lord, it's from BTC.
Appearing for BTC, Lordship. He is appearing for BTC. I am appearing for
Oh, acha.
Agriculture Department, Lordship.
Okay.
1 and 4 government, my lord.
Okay, 1 and 4 will be government. Your name?
2, 3 and 5.
Zipora for Agriculture Department.
Ms. D. Boral, and government advocate, Learned Standing Counsel for the Agriculture Department, representing respondent number 1 and
4, Lordship.
4. And he is appearing on behalf of BTC.
2, 3 and 5.
Counsel for BTC, representing respondent numbers 2, 3 and 5. Agree by the penalty imposed on the petitioner by order dated 10/2/2023. Passed in,
And it's 10/6, my lord.
no, it is 10/6.
10/6.
Oh, okay. 10/6/2020. By which the penalty of stoppage of 2 increments with cumulative effect was passed against the petitioner. The present writ petition has been filed under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition will be served on the honored state and departmental counsel in the course of the day. Next for the list after 4 weeks.
Deputy officer.
Value please.
18.
May this Lordship kindly bus up for time being.
Okay. Participant.
Obliged.
19.
Item 19.
Here the petitioner is a pharmacist, my lord. We are challenging an order, my lord, by which the transfer of the petitioner has been cancelled. Now, my lord, that order, my lord, will find in page 18. Page 18, my lord, is the order we have put to challenge.
Where is the transfer order?
Transfer order page 15, my lord.
16, yes.
1-5.
1/5.
1-5.
Yes.
Transfer order, my lord, first one. Abdul Samad, the petitioner, pharmacist of Ambari Bazar Dispensary, Ambari, is hereby transferred and posted in the same capacity and same scale of pay vice Nurul Haq, pharmacist of Bhagwan State Dispensary within the same district under the establishment of Joint Director of Health Services, Golpa. This order has been stayed by the order at page 18, my lord. And subsequent to the passing of the order at page 15, my lord, he has been released. That release order is page 16. Thereafter, he joined, my lord. Page 17 is the joining report. Now, my lord, and from the face of it, the order at page 18, it has been passed on the verbal instruction of the commissioner, my lord. Now, my lord, here the petitioner, he is working in the Department of Health Services, and the order was given by the district director of health services. And now this order is being passed on the verbal instructions of the district commissioner and by the joint director of the health services, Gwalpara.
No, because there's a,
Appointing authority is
there's a
the-
government circular which says that inter-district transfer can be done by the deputy commissioner,
Yes,
district commissioner. That was placed before us on the last week. Mr. Chakravarti?
and apparently, my lord, no opportunity has been granted before cancelling this transfer order. That ought to have been given, my lord. As per verbal instruction of the honorable.
No, because that
Commissioner.
is permissible. Mr. Chakravarti, please find out order by which the deputy commissioners are now permitted to transfer. Where is that?
Lockney Lodge. Lockney at home Lodge.
Okay.
And further, my lord, no opportunity was given to the
No,
petitioner.
opportunities are not required to be given.
He has been released, my lord, from the earlier posting, my lord, and now after cancellation of this order, of the transfer order, he is not being able to join any post.
Yes, but have to give him somewhere. Mr. Bara.
My lord, by order at annexure 2, my lord, he has been placed here by the director, my lord, appointing authority, my lord. By the order dated, my lord, 1/3/2024, my lord, at annexure 2, my lord. My lord, the petitioner has been placed at particular one place of posting, my lord. And the director being the appointing authority, he has placed the petitioner, my lord, there, my lord.
No, but that has been he has also joined.
He has
He is showing at page 17, he has
Yes,
joined
my-
there.
Yes, my lord.
After joining, this order has come.
Yes.
Yes, my lord.
Transfer is cancelled.
Cancelled by the joint
Joint
director, my lord. It says there on the verbal instruction of the district commissioner, my lord.
No, but where does he draw his salary? Just tell us only one thing.
Yes, my lord.
If that transfer is stayed after joining, where will he go?
My lord, because my lord, director, my lord, the director of health service, he has posted a person in a particular place, my lord. So if it has to be modified, probably the director can do, my lord, being the appointing authority, my lord. Director can do, my lord, being the appointing authority. What I understand, my lord.
I mean, the position is.
No, you see, director transfers. Joint director stays.
Cancels the order.
So joint director is more powerful. He has got two words, joint
Yes,
director. Director is only one single word, director.
Yes, my lord.
The joint director is more powerful. Now your director should take for his permission where to post him.
My lord, or let me obtain instruction from the director, my lord. Thereafter-
Otherwise, we'll direct your director to take instructions from the joint director
Yes, my lord.
and place him somewhere. Correct.
Yes, my lord.
Designation is two words, joint
madam.
director.
Till such instruction is taken.
At
madam,
2
may-
o'clock.
may
Let
I-
him get it at 2 o'clock.
My lord, at 2 instruction, I'm not sure. Can it be tomorrow?
No, tomorrow we have a special bench.
Tomorrow, day after tomorrow, my lord.
Huh?
Day after tomorrow, my lord.
Tomorrow, day after tomorrow is long list. Try to get it, we will get it. Try to
Yes,
get it, if not, we'll adjourn it, but
Yes,
try to get it.
Yes, my lord.
20.
At 2.
Yes, Mr. Mahanto.
Yes, my lord, this is suspension and it is prolonged suspension. My lord, suspension order and Annexure 7. 12 January,
Okay,
with retrospective effect from 5/1/24.
okay, you're not being charge sheeted?
No,
in
no,
department
no,
today?
nothing has been done. Well,
But
others
Mr.
will
H.K.
raise
Mahasal,
my
and
lord.
counsel for the petitioner also heard Ms. D.
Z Bora Lordship.
G. Bora Leonard, government advocate appearing for respondent number.
One and two.
For all the respondents,
1 and 2 Lordship.
respondent, Mr. Standing Counsel for Agriculture Department, representing respondent numbers 1 and 2.
My lord, I am
Mr. R. Borpujai, and Standing Counsel for the
finance.
Finance appears for respondent number 3. Accountant General, Mr. S.K. Mehdi, Leonard Standing Counsel for the Accountant General, representing respondent number 4. Next, continued suspension of the petitioner. Right, order dated 12/1/2024 is assailed in this requisition filed under Article 226 of the Constitution of India. Issue notice returnable on.
My lord, here, my lord, the authors of the case, it is very clear about it.
In motion, I am not disposing of without.
My lord, let them take instruction on Wednesday.
No, not with this day, after vacation.
And it will be too long, my lord. He will retire next year. He will retire next year, my lord.
When?
July.
First July, he is retiring.
2025 Lordship. July 2025.
Oh, then we have a lot of time.
My lord,
Don't worry. No.
my lord,
We can't tax ourselves.
my lord, that
No, you have waited for so long. Why? For 15 days, no heaven will fall.
because some time was given to them, my lord, but they have not taken. My lord, may they
No.
take instructions, my lord?
Rate petitions I am not disposing of at the motion stage at no cost.
Then, my lord, if that may be fixed.
Return of the one. 19/7/2024. Requisite extra copies of the rate petition be served on the honored state and department council in course of the day. List on so and so. You have your instructions.
Lordship.
on the day. Because Ajay Chaudhary applies them.
21.
That is fixed, my lord.
You've already given a date. Yes.
When the petitioner was serving as a constable in the 30th Assam Police Battalion Lordship. And an FR lodged by a third party against the petitioner Lordship. The departmental proceeding was started and ultimately his service was terminated Lordship. Then he filed the departmental appeal that has been also rejected, against which the present petition has been filed. The notice may be issued.
Heard Mr. S.P. Royal and counsel for the petitioner. As well as Mr. R. Dhar Leonard, additional senior government advocate appearing for the respondents.
All the respondents, my lord.
Next paragraph. Agreed by the order dated 11/8/2023, issued by the Commandant 13th AP Battalion, by which the petitioner was dismissed from service, as well as the appellate order dated 5/10/2023, by which the appellate authority had dismissed the appeal of the petitioner. No, sorry, 2/3/2024 is the appellate order. Assailed by the petitioner by filing this rate petition on Article 226 of the Constitution of India. Next, issue notice. Returnable in 4 weeks. Requisite extra copies of the rate petition be served on the honored additional senior government advocate in course of the day. Next, list on so and so.
All right.
List after 4 weeks.
22.
Please, Your Lordship.
Yes.
My lord, the petitioner, Your Lordship, is challenging the legality and validity of the uniform departmental proceeding, my lord. Because, my lord, section 2N says, my lord, something else, and complaint says something else, even though, my lord, I was being booked and departmental proceeding is going on against me as a sexual offense, my lord. But that cannot, my lord, lordship may be aware, my lord, I have quoted also, my lord, what are the conditions to be sexual harassment, my lord. Lordship can have a look, my lord. I have reproduced in at page, lordship will see at page 53, my lord. In the middle, my lord, I have quoted the definition also. What is that about, my lord? Includes any of the mauling? Or lordship can have a look my book.
Yes, please continue.
My lord, at page 53, my lord, section 2 and definition is there, my lord.
Page?
Page 53. Middle paragraph, my lord. 2 and.
Yes.
May I read, my lord? Harassment includes one of the following unwelcome acts, behavior, or directly or indirectly by the implicit physical contact, demand, request, and making sweats of favor, remarks showing the pornography or other unqual physical or verbal or non-verbal contact of the sexual nature. These are the conditions has to be there, my lord. But complaint, lordship will see the complaint, my lord. What is the basis of the complaint, my lord? Page 26 is the email, my lord. 26 and 27. Does not contain any contents of sexual harassment, my lord.
Yes.
Lordship will see page 26 is the email, my lord, basing on which the complaint was initiated, my lord, page 26 and 27. If your lordship permit me, I'll just read out.
No, just don't, today is not a time when you'll
Yes,
be
yes,
given
yes,
opportunity of reading everything.
Yes, my lord.
Tell us in short what you want to
In
say.
short, my lord, the email contents does not attract, my lord, section 2N. But departmental inquiry, my lord, was initiated against me, and basing on the recommendation, my lord, a departmental proceeding was initiated against me, and a impugned report was submitted upon me, my lord. That your lordship will see at page report, as page 32, my lord. By the committee constituted by sexual harassment of women at workplace prevention of section 13, my lord. But recommendation was that, my lord, last line, my lord, gravity of the committee recommended the urgent disciplinary action against Dr. Halim, Registrar of the Pediatrics, Guwahati Medical College, my lord. That cannot be, my lord. Because, my lord, I have already given my reply to that, my lord. It cannot proceed against me because of the reason, my lord, the section does not fall within the section 2N. But even though, my lord, they have initiated against me, my lord. Inquiry report also submitted, my lord, operative part of 48 and 49, my lord. Now they are going to take action against me.
This is page 32 is the report of the ICC.
My lord. Yes, my lord. It is also not emphasized, my lord, what has been done by me.
Haji,
Lordship can have a look my copy, my book.
sexual harassment of women at workplace. Now you see, as per this act, this report of the internal committee becomes an evidence. And it is a document upon which action can be taken, action has to be taken. There is a mandate. Therefore, why in a writ petition we should examine it? The best authority is to examine it is the departmental proceeding.
My lord, we have intimated to them, my lord, that matter cannot be taken up, my lord, but no action has been taken, my lord, which I have shown to your lordship as space.
In a writ petition, it cannot be quashed. A report of the ICC cannot be quashed in a writ petition.
My lord, entire proceeding I have challenged, not only report, my lord, entire proceeding. Entire proceeding against me, my lord, I challenge to that.
You can't.
And my lord,
You
because
can't, because of the act says once
lord.
the report is there, the action has to be taken. So therefore, there is no way that it can be.
No, my lord,
it can
action
be
has to
certified
be
and quashed.
taken subject to the parameter laid down in section 2N, my lord. Section 2N definition is there, my lord. What constitute the sexual offense? From
You
her,
see, everything is apparent. The victim gives gives an allegation against you. She says that you give her inappropriate SMS, you give her an inappropriate
SMS did
message.
not say, my lord, only mail she said. Mails, page 28 she said.
I don't know. I'm just reading the document which is there in my board.
Yes.
It says that your messages are what you call, they are the actual word used is inappropriate.
Inappropriate.
Yes. So that goes,
Inappropriate, my lord.
that is examined by the head of the
My
department.
lord,
It
yes, why I am
then
before
goes.
your lordship. Lordship is holding this book, my lord. Lordship kindly have a look, section appeal, my lord, where to go? Section appeal, my lord, we have to go to the tribunal or to the court. Lordship kindly have a look, section 18, my lord, appeal provision. If a complaint, if a lordship permit, I'll just read out, my lord. A person agree from the recommendation made by in this section 2 of section 13 clause so and so subsection 3, 4 of section 13 subsection 2 and 14 and 17 or non-implementation of the such recommendation may prefer an appeal to the court or to the tribunal in accordance with the provision of the service.
That is
rule.
notified. And still, the authority is already notified.
Notified, my lord. Lordship
Then
kindly
you
see
go there. If you
against, my lord, any recommendation where to go, my lord.
There's an appellate authority. You have to go there.
My
only.
lord, appeal or the court or tribunal in accordance with the provision of the service applicable to the said person who knows our service rules exist then without prejudice to the practice and so law.
Come to rule 11. Answer is there. Come to rule 11. The answer is there.
Manner and organize of the works are subject to the provision of the so and so formulate to widely distribution and internal policy character of a resolution declaration of prohibition prevention of the redressal sexual but no sexual harassment is there.
Even after that letter, you say it is not there, then we can't.
My lord, workplace intended to promote a gender sensitive the safe spaces remove underlying facts.
No, are you suggesting that the girl should write what was inappropriate in that message, give a description of the.
No, my lord, not that, my lord.
Then
My only.
how will the girl say she is a student, you are a teacher?
Yes, my lord.
She says that you have approached her and your actions are inappropriate. What else she can say? Unless you write, okay, no, henceforth every girl will have to give description of what is the nature of sexual harassment. Yes,
My lord, from the
nothing
complaint also,
acceptable.
my lord, does not indicate, my lord.
So I am reading something foreign.
No, my lord, from
Then-
the complaint, lordship will see
if I am reading a document which says there is, there
My
are
lord,
documents,
inappropriate is there, my lord.
then
This type of nuisance towards me
that's
and
why I'm
therefore,
asking you, Mr. Barbuya, are you proposing as a council, are you proposing that the henceforth any complaint by a sexually harassed lady
my lord.
should give a descriptive description of
No, my lord, I
how she is
don't.
harassed?
No, my lord, I
That
don't.
can't be.
I don't know. I don't.
Then
My lord, only my lord, at this moment, my lord, page 16, my lord, I have given to elaborate, my lord, my explanation. They have to come to the some logical conclusion. That has not come, my lord. Let them take instruction on to that, my lord.
no, we don't require that. Section 7(4) says that this amounts to the report is this report is to be acted upon. Internal committee section C 13(4). 13(3) says where internal committee or local committee as the case may be arrived at a conclusion, action has to be taken. 4. The employer of the district or the officer act upon the recommendation within 60 days.
My lord.
Now we can't quash that.
My lord, basic grievance of the petitioner is that, my lord, he did not cause any untoward anything or any bad thing, my lord. He made
Something is not one. It's second time. It went to your departmental authorities. They examined it.
and
then
now, my
again there
lord,
was
I
a
am no more
repetition.
there, my lord. I have gone to the Barpeta, my lord. Barpeta, my lord.
Whatever you, wherever you go, we can't say about that. Those are not within our domain. But what is within our domain is that there is a complaint, explicit complaint.
My lord, that day, my lord, lordship fix the matter. After tomorrow, I'll take instruction whether
No,
to
no, no,
proceed
no.
with the case
No,
or
no,
will
no. Once
withdraw
we
it.
take up the matter, then you see, it has become a regular practice. You knock the gate of the court, hear the comment, and then say, okay, not today.
No, my lord, at 2 o'clock, my lord, lordship will take, my lord,
No.
I'll go for withdrawal of the case also, my lord. That's what
No.
only 1 minute time may be granted to me. I'll take over phone, my lord.
Because when you apply a mind, after that you
My
say
lord,
that, well,
5 minutes time be granted to me, my lord. I'll just take up the instruction to withdraw it, my lord. Nothing else, my lord. That
because that is why now I realize when I was practicing, I was offended by the judicial magistrates not speaking their mouth. They will keep silent. I was annoyed that while arguments are made, why the judicial officers don't react. Now I have learned that it's better not to react.
my lord.
Be silent and then do whatever you want. Nobody is going to question you. Once I ask questions, then I take the receiving end.
After some time, my lord, or at 2 o'clock.
Yes, Mr. Sekia.
The matter, maybe senior counsel Ken Chaudhary is still not ready.
Yes, she is not there.
So could it be taken after reopening, Lordship, on the reopening day, 15th?
You are doing it.
I am for the respondent, but that cannot be my prayer. But
No, he is doing it. Mr. Patwari is doing it.
Lordship.
Item number 14.
Let me get it. Why not, the issue here, the OBC caste certificate issued to the petitioner was altered with by the state level scrutiny committee. And assailing the said decision, the petitioner in the earlier round of litigation filed a writ petition. And the writ petition is allowed, and the order of the state level scrutiny committee was interfered with. Thereafter, the private party who filed the complaint against the OBC certificate, they went into appeal against the order of the learned single judge. The Honorable Division Bench also upheld the learned single judge order as well as my OBC caste certificate. Now, my lord, during the currency of the Honorable Division Bench order, the state authorities have again conducted an inquiry into the veracity of my caste certificate. In fact, two inquiries, my lord. And my lord again issued a so-called notice to me based on those subsequent inquiries, my lord. In my humble submission, my lord, during the currency of the Honorable Division Bench order, the state action is, my lord, not permissible. Lordship will kindly straight away turn to the Division Bench order.
Yeah.
Yes. Lordship
Which
will,
page?
yes, Lordship will,
Which page?
Lordship will find the Division Bench order at page, my lord, 147 it starts. 147.
Yes.
My lord will kindly come to the relevant portion, para 15, at page 159.
Yes.
May I read para 15, my lord?
Yes.
Testing the report of vigilance officer, that is the inspector CID, on the touchstone of principles laid down in the case of Kumari Madhuri Patil, we found that the inquiry report submitted by the inspector CID does not indicate even in the slightest that the particulars given by the candidate were false or that the social status certificate has been fraudulently obtained. Thus, in terms of the first part of the paragraph 13.7 of the guidelines formulated in Kumari Madhuri Patil Supra, which provides that in case the report is in favor of the candidate and found to be genuine and true, no further action is needed to be taken. No further action was called for in the present case after the detailed and recent inquiry report had been submitted by the inquiry officer. However, the state level scrutiny committee got another parallel inquiry conducted through Circle Officer Jorhat Revenue Circle, who apparently had no jurisdiction to carry out as indicated above. Subra. Another significant fact which needs to be noticed is that the report of the Inspector CID, which was submitted after conducting a thorough inquiry in terms of Kumari Madhuri Patil, did not give any indication that the social status certificate was obtained by the respondent with petitioner by providing any false or fraudulent information, rather concluded that the social certificate was validly and lawfully obtained. The authorities had no option but to accept the report and affirm the social status certificate of the respondent with petitioner as per the guidelines contained in paragraph 13.7 of the judgment in Kumari Madhuri Patil. Hence, the contrary conclusion drawn by the state level scrutiny committee is absolutely illegal and unwarranted. As a consequence of the above discussion, we are of the firm opinion that the learned single judge was perfectly justified in accepting the respondent number 1 hearing and quashing the speaking order dated 26/2/2021 passed by the state level scrutiny committee and affirming the social status of the respondent number 1 hearing at OPC coach. Thus, the impugn order does not suffer from any infirmity, and as a consequence, the writ appeal falls and the same is dismissed as being devoid of any merit. Now, my lord, during the currency of this order, two subsequent inquiries are, my lord, directed by the state authorities, again into the veracity of my OBC caste certificate. Those two subsequent inquiries are being assailed in this petition, and a so-called notice has been issued based on those two certificates, inquiry reports. My lord. The first impugn inquiry report is at page 185. And the second impugn inquiry report is at page 211. And the impugn so-called notice at page 216. The state government filed a review against the division bench order that was withdrawn subsequently.
No, but the only question is,
My lord.
you come to NHA 2023, that's page 177.
177, yes, my lord.
The last,
No, 177 review, my lord, subsequent to the division bench order, I was kept under suspension. Despite dividend bench order, I was not, my suspension was not revoked. I filed a writ petition for revoking my suspension. That was allowed. Against that writ petition order, this, my lord, 177 order is there. Last annexure 29 is the review against the dividend bench judgment. Page 177 is the single bench review, revoking my suspension, my lord. That was also dismissed,
No, that's okay.
my lord.
But this page 177, it starts.
My lord.
Come to page 184, paragraph 13.
My lord. Yes,
The court has put a specific query upon Mr. D. Nath.
Yes.
So and so.
yes.
Inquiry has been done for the purpose of cancellation. Further inquiry has been done for the purpose of so and so, because so and so, the only process is initiated, but also is already restored, holds we feel.
Yes.
So and so. Now, last part it says, how the court observes that the rejection of this review application and observation made herein shall not be considered as that this court has made any observation debarring the rights of the review petitioner to take such action as permissible under law. So if with that liberty, if they embark into a fresh
No, no. my lord.
examination,
This is in respect of revocation of suspension only, the review. The writ petition was, my lord, revocation of suspension pursuant to division bench judgment, my lord. The review against the division bench.
No,
that
no.
order,
Para
final
13,
page
para
29.
13 is very clear. Further inquiry has been done for the purpose of cancellation of OBC certificate.
Yes,
But the government advocate said that the OBC certificate is restored in our favor, holds field. And then court goes on to say, under
Yes.
such circumstances, the opinion of the court, that unless and until the basis of edifice on which the suspension is not restored.
yes, as permissible under the law. So when the division bench order is holding the field, can there be subsequent review without taking leave of this honorable court, my lord? So the honorable division bench direction will become redundant then, my lord.
No, I'm sorry, my lord, I was on legs in.
Mr. Chaudhary, I have only one question to you.
Yes.
I have said to Mr. Patwari, page 177,
Yes,
the last part is at page 184,
yes,
para 13.
yes.
Because if the court has given the
Liberty,
liberty,
yes.
then why they cannot embark upon a fresh inquiry?
No, my lord, fresh inquiry cannot be made because the issue is already decided. Then what meaning we give to public policy? Then what meaning we give to res judicata? Well, it's a very, my lord, it's a case where state is abusing its authority, my lord. My lord, it was never our case that my father is not a general category candidate. Yes, my father was general category candidate. My lord, let me make one position very clear. In view of the law laid down by the Supreme Court in that Kane Commissioner's case, even Chief Minister cannot interfere in this case. He is nobody. And the law is meant for all. Merely because Chief Minister has directed inquiry, that does not give any legitimacy to an inquiry which is otherwise not permissible. My lord, this under the scheme of the Madhuri Patil's case, it is the vigilance inspector who is. My lord, please come to the division bench observation for a moment. If your lordship will kindly come to the DB order at page 177, it starts at page 159. Page 159, para 15. Testing the report as a lordship. Testing the report of the vigilance officer
that is Inspector of CID on touchstone of the principles laid down in Kumari Madhuri Patil. We find that the inquiry report submitted by the inspector does not indicate, even in the slightest, that particulars given by the candidate were false or that the social status certificate had been fraudulently obtained. In terms of the first part of para 13.7 of the guidelines formulated in Kumari Madhuri Patil, which provides that in case the report is in favor of the candidate and found to be genuine and true, no further action needs to be taken. No further action was called for in the present case after detailed and reasoned inquiry report that had been submitted by the inquiry officer. However, SLLC got another parallel inquiry conducted through Circle Officer Jorhat, who apparently had no jurisdiction to carry out such an inquiry. So this observation will apply to an inquiry made by at whosoever instance it is.
No, but you see, here also there is a fact noted at page 159
Yes.
that the Krishna has obtained a caste certificate belonging to Koch OBC community.
Yes.
His mother is of the said caste.
Yes. That is the law, my lord. Perhaps I'll have to address your lordships on that point. My lord, supposing my father is an upper caste, my mother is a lower caste. If I can demonstrate that I was born and brought up in the customs to which my mother's family is accustomed to, then I am entitled to. It is on that basis I got it. Ramesh Bhai.
Let us see where
Yes,
it
yes.
is held where.
Yes. My lord, it was never our case that my father is an OBC. Also, it was our case that my father is a general caste. My lord, this is the judgment Ramesh Bhai, Dab Bhai Naika versus State of Gujarat, 2012 3 SCC 400.
2000.
2012 3 SCC 400. Ramesh Bhai, Dab Bhai Naika versus State of Gujarat.
Yes.
If your lordship would kindly come to para 53, the sentence starting with in Aurobindo Kumar Saha versus State of Assam.
Yes.
In Aurobindo Kumar Saha versus State of Assam, a division bench of the Guwahati High Court had a case before it in which a person whose father belonged to upper caste and mother to an SC caste claimed a scheduled caste status. The court found and held that though the father of the writ petitioner was admittedly a forward caste man, he was brought up as a member of the scheduled caste. This was evident from the fact that writ petitioner had not only been an office holder of Anususita Jati Karmachari Parishad, but scheduled caste community treated the appellant as belonging to scheduled caste, and even non-scheduled caste people treated him as scheduled caste, in as much as in his college career and in his service career he was treated as a person belonging to scheduled caste. In view of the analysis of the earlier decision and the decision made above, the legal position that seems to emerge is that in an intercaste marriage or a marriage between a tribal or a non-tribal, the determination of the caste of the offspring is essentially a question of fact to be decided on the basis of the facts adduced in each case. The determination of a caste of a person born of an intercaste marriage or marriage between a tribal and a non-tribal cannot be determined in complete disregard of the attending facts of the case. In any intercaste marriage or marriage between a tribal or a non-tribal, there may be presumption that the child has the caste of the father. This presumption may be stronger in case where the intercaste marriage or marriage between a tribal and a non-tribal, the husband belongs to the forward caste. But by no means the presumption is conclusive or irrebuttable, and it is open to the child of such marriage to lead evidence to show that she was brought up by mother who belonged to the scheduled caste and scheduled tribe. By virtue of being son of the forward caste father, he did not have any advantage start in life, but on the contrary suffered deprivation, indignities, humilities, and handicap like any other members of the community to which his or her mother belonged. Additionally, he was always treated as a member of the community to which her mother belonged, not only to that community, but the people outside the community. So law is, my lord, in a given case, even if the father belongs to an upper caste and mother belongs to lower caste, then it depending upon the facts of each case, and if it can be shown that the person was born and brought up in the custom of the mother and was subject to the indignities and disadvantages, then that will be done. In this case also, my lord, if your lordship kindly permits me to place page 141, that's the report of the inspector. Judgment has been upheld by the division bench. Page 142.
Yes.
As entrusted, I visited the different given locations of the alleged person and found the findings which have been presented below. In respect of Monsoon Borkakoti, I visited her paternal address and present address, that is Golaghat and Jorhat. In course of inquiry, it is found that father of the alleged, namely Khantanu Borkakoti, born and brought up at Silpukuri, Guwahati, followed the original rights, that is rights of Kolita community, and got appointment as medical officer who was posted at Jorhat. The said doctor got married with a lady at Jorhat, hailing from Koch community, and used to reside at matrimonial house where the alleged Miss Monsoon Borkakoti got birth at her mother's house on 12/4/1990. And since then, she started her education at Jorhat and accepted the customs of the Koch community. During 2006, while she was a student of class 9, she applied for OBC certificate, caste certificate on merit of her mother's custom. It is a fact that the father of the alleged, though got appointment as MBBS doctor, however, he has not moved for OBC certificate as he was not born on OBC Koch community. It is pertinent to mention here that in respect of issuing OBC certificate, Honorable Supreme Court of India passed a verdict referred to in, this is the same case which I read. In connection with the appeal, the Honorable Supreme Court of India passed the judgment that the child generally belongs to father's caste. However, child can claim mother's caste also in certain situation. And if the child is born and brought up at the house of the mother, who is hailing from other community, then for that of her father, it is a fact that the judgment promulgated not directly related with OBC community. However, the situation incorporated carried ingredients for which alleged Monsoon Borkakoti is seemed to be entitled for OBC caste certificate. Moreover, issuing agency clarified that certificate issued is genuine and issued from their office. The photograph of OBC certificate. The photograph of OBC certificate issued by the president. Copy of the certificate issued by local Gambura named Manto Borua of so local certified by Sri Hazarika. A copy of the judgment of the Supreme Court are enclosed here. So this is an issue, my lord, which has attained finality. Not only once, a single bench as well as a division bench. My lord, in fact, this state filed a review petition. Then review petition was argued for more than 4 days. But the Honorable Division Bench did not accept the review petition. Ultimately, state had to withdraw. My lord will kindly see, I got this certificate in 2006 when I was in class 9. My mother had to take this certificate subsequently because, my lord, when my mother entered service of Government of Assam, at that point of time, OBC, the Koch Rajbangshi was not recognized as an OBC. It was done only in 1993. Even at one point of time, Koch Rajbangshis were sought to be conferred with the status of STP also. There were 3 successive ordinances issued. I as a CGSC had the occasion to defend those before this honorable court. Eventually it lapsed. So they went back to their original status of OBC. My father is a general class. It is never our case that my father belongs to OBC. Unnecessarily, Lord, this state is poking their nose in a matter where there are hundreds of thefts going on in the Guwahati city. Not a single theft is being caught. Now thereafter this girl money. I do not know who is so interested.
Yes.
My humble submission is, here is a case where I can demonstrate, my lord, the state is abusing its authority. Some influential persons are involved. That's why, my lord, inquiry after inquiry is going on. My lord, they have started a criminal case against my father. In fact, my lord, review was filed on 3 grounds. All those 3 grounds, my lord, were taken note of by the division bench judgment. When we demonstrated all these things, state had to withdraw the review petition, my lord. And now I have been reinstated also. So why this inquiry, my lord? Where is the difficulty? Otherwise, my lord, there will be no end to any litigation. Then what meaning we give to public policy? Or if your lordship wants that I should address your lordships in detail, lordships can have this matter after vacation also, my lord. Because tomorrow and after, since I'm contesting in the election, I have some commitment also.
Yes, Mr. Saikia.
In that case, Lordship, let the matter be taken up on 15th. Let the matter be adjourned till 15th. Because whatever my learned friend is saying, I have contra-argument on each and every point. The case was not withdrawn because the court was not accepting. The court come to a conclusion because we have issued the so-called notice on 28th of December on the basis of the 26th December inquiry report, the second inquiry report. Then she said that 2 inquiries cannot be proceeded at the same time. The Honorable Court gave us the option whether you want to pursue the review or you want to pursue the so-called notice and the inquiry. We said that we'll pursue the inquiry. That is, Lordship will kindly come to the last page of this bunch of papers, 217. How the review order was withdrawn. We have issued a so-called notice at page 216 on the basis of the report of 26 December. Now, Lordship will kindly come to her reply at the last page, page 218. She said, further, the second last page, paragraph of page 218. Further, the subsequent inquiries and its findings are presently sub judice before the Honorable High Court in a review application filed by the State of Assam against a judgment and order dated so and so. Therefore, in my humble understanding, parallel adjudication on the issue involved, that is determination, entitlement of the social caste certificate is not permissible in the eye of law. So 2 parallel proceedings were going to review as we decided to withdraw. The withdrawal order is at page 200 and the last. Lordship will kindly see that order.
My lord, state also sought permission to undertake that second inquiry. That was denied by the division bench.
No. Now my friend is now caught, therefore he is shouting. It is not.
Okay.
He said that we came to a conclusion, we have to withdraw. We have to withdraw because we want to pursue it. It is written there in that order. Lordship will kindly see that order.
221.
221.
220. My lord,
Yes, the learned advocate general on instruction has submitted that the state does not want to place this
litigant may
petition
file
since.
hundreds
a
of
moment.
petitions.
Just
Question
a
is
moment.
whether those
Mr. Chaudhary,
petitions are maintainable.
let him complete his part.
I did not interfere at any point of time. Lot of things were saying against the chief minister also. I did not interfere. The learned advocate general on instruction, because the previous day court wanted to know which option do we want to adopt. Therefore, on instruction, we said, has submitted that the state does not want to praise this petition since they are pursuing with the inquiry initiated by them against the writ petitioner. Review petition is closed as not praised, not dismissed.
But,
So,
but Mr. Saikia,
Lordship.
there will be a question.
Yes, Lordship.
Once a division bench gave a verdict,
Lordship.
then how far you can engage? in
Yes,
the
yes.
inquiry?
There are two issues. We wanted to, the division bench second order came on 1st of June 2023. On 14th of June, the state government reviewed the whole thing. In fact, on 19th of May, the state government requested us to file the appeal. We prepared the appeal and about to file. When we are about to file the appeal on first, the third party who had a respondent, private respondent who lost the original complaint, their writ appeal was dismissed. We could not file the appeal because already it was decided. So we had two options, either to file a SLP before the Supreme Court or we have to file a review application. The government found that two very contradictory reports. One report, the inquiry done by the ADC at that instance of the Deputy Commissioner, which said that this certificate was bogusly obtained, number one. On the other hand, the police officer who did the inquiry, he found that it is rightly given. So the government came to a conclusion that why two authorities of the same government is finding two different findings. So government wanted to know and directed the CID to find out whose inquiry report is actually correct. That report came in November. That actually the police officer who did the earlier inquiry, it was a totally perfunctory inquiry. He relied more on law than on facts. Therefore, government said that now we have come to a stand that the inquiry on the basis of which the learned single judge as well as the division bench gave the judgment in favor of the writ petitioner as well as the writ petitioner present also. Therefore, government wanted to know that government want to place it before the honorable court by filing a review application. Because at that point, we cannot go to the SLP. Our option was to go to SLP. Then we brought all the facts to the honorable court, including the 26th December's report also. I argued the matter for 4 days. The other side also argued. Then this response to the so-called notice of 28th December, she said in January that two parallel inquiries was going on. The honorable court rightly put that question to me, that there are two parallel inquiries going on. We cannot permit you to proceed in two different levels, two different forums. So you take a call. Then I took adjournment. And we decided and we discussed the matter at the government level and came before the honorable court on 28 May 2024 and said that we want to pursue the inquiry, to which she has already responded. Her reply is already there. So they have participated in this inquiry by saying that two parallel inquiries cannot go on. That is one ground. So we withdrawn it. Now we want to pursue that. Whatever ground she would like to take here, she can take in the so-called note reply also. And after that, only the actual inquiry will start. Because to the so-called notice, if she convinced that we do not have our inquiry of 26th December is not correctly done, we may not go any further also. We may close the whole chapter. But that option she have to adapt at one point of time, because the Honorable Supreme Court in 2026 in a very straightforward case said, if the inquiry is not done properly, if it was perfunctorily done, then second inquiry and multiple inquiries are permissible. This also judgment was taken notice by the Honorable Division Bench. We can always go because we found that the police officer who did the inquiry at the first level, he did not find out the many vital facts. Those vital facts, why now? One important issue. Why the father's case has been registered against him in Dergaon police? Because in 2019, he also obtained a OBC certificate.
No, but Mr. Saikia, why this inquiry should not be made by the, as per the Madhuri Patil's case?
We have done as per Madhuri Patil's case, Lordship.
No.
Now we are totally going as per Madhuri Patil. whatever we are doing, there is no deviation. Only deviation was that at the deputy commissioner's level, another inquiry was done.
No, wherever you constituted a caste scrutiny committee.
Now, that committee will now take over. Now the director has issued this so-called notice. Once she replies, and if the director finds that there is scope for further inquiry, then the caste committee will give proper notice, where she can lead evidence also. Now, the law which my learned friend was showing.
Is the caste scrutiny committee nominated in Assam?
Yes.
Yes, we have a 4 or 5 members committee. As per Madhuri Patil's it originally said 3 members, now it has to be 5 members. So we have the full committee. There's a notified committee is there, Lordship, as per Madhuri Patil.
Of the matter is, for that SLSC decided against me. Against that, we filed the writ petition. Writ petition was allowed. SLC's finding was set aside. Then another party went in appeal. Landed single judge's order maintained. Now that is the position. There is no question of again going to the SLSC. SLSC has already decided.
My humble submission, Lordship, as my learned friend is also wanting to argue the case on the reopening. In the meantime, we will file a short affidavit. Certain documents they have not annexed in the writ petition. So we will file a short affidavit, and on 15th, Lordship may hear the matter, maybe for interim or for final disposal, if the other party agrees.
Yes, Mr. Chaudhary.
Yes.
Then I'm issuing a notice.
Lordship, only a notice, Lordship, at this stage.
Notice also on the interim order.
I agree, Lordship, no difficulty.
Heard. Mr. K. Chaudhary, Learned Senior Counsel, assisted by Mr. J. Patwari, Counsel for the petitioner. Also heard Mr. D. Saikia, Learned Advocate General for the State, assisted by Mr. D. Nath, Learned Senior Government Advocate. Appearing for respondents. All the respondents, Mr. Nath?
Yes, sir.
All the respondents. Requisite issue notice of motion, including notice on the prayer for interim relief, returnable on
16th, Lordship. On 15th, we will file the affidavit on the reopening day. Next day, Tuesday, it will be proper day.
17th.
17th is a Wednesday, then let it be 18th, Lordship. Let it be on 18th.
Okay.
Because it will take some time, Lordship.
Go. Requisite extra copies of the writ petition we served on the Learned Senior Government Advocate within 3 days. If any by the state respondents shall be filed within 16/7/2024 with copy to the Learned Instructing Council for the petition.
Okay.
List on 18/7/2024.
Deeply obliged, Lordship.
Thank you.
Continue post lunch.
No.
Time being item 11.
Who has been rejected his pensionary benefits in the year 2022.
Just wait, somebody was there. CGC was appearing here.
Yes.
Mr.
11. Item 11.
11, you'll be appearing or somebody else is assigned?
Time being.
Oh. Lordship, I can.
Only notice. Yes, you were found unfit.
My lord. I was, my lord, my services were terminated on the ground of being not fulfilling the medical conditions. After I was recruited, Lordship will find at page 25. They had promised me a disability pension at page 25, my lord. The type copy.
Yes.
They said reference to Assam Rifle Training School data number so and so. It is to inform you that disability pension for persons who have been discharged from service on medical ground has been approved. Hence, you are hereby directed to report to ARTC and school for making and signing of pension claims along with following documents. Now I went there, my lord, and thereafter Lordship would find at page 27.
Yes.
They tell me that my minimum pension has been fixed at 2,500 per month. Thereafter, my lord, at page 30, a letter comes that I have been already paid my service gratuity. I have been paid my IRLA ledger account, and that I may not be entitled for any further pensionary benefits. I keep corresponding, my lord, and if Lordship finds at page 35, 15th of November 2022, my lord, they finally reject my claim for any disability pension. And before this court, my lord, challenging the discharge order. If it was a wrong discharge order, then my lord, I should not have been terminated. And if the discharge order is correct, then I would be entitled to whatever pension that flows from it. In similar matter, my lord, notice was only issued.
Notice, okay.
Respondents were
But, what is the disease?
My lord?
What is the disease?
My lord, the feet, my lord. It is a disease relating to the feet, my lord, that is called CPSM. I had gone through this. Then the full form. I'm going to call it right now.
This is swelling of the middle eye, middle ear.
My lord, yes.
This is, they say that they are not, this is not in.
It was neither aggravated nor attributable to service. But when I had joined the force and I was under the training, it is at that point of time they put me through a medical test and they found that it was not a test.
It can come up anytime, this disease.
Therefore, there are judgments to show that if it is during training also, if it happens during training or it is aggravated during training, even then, my lord, I would be entitled to a disability pension. My lord, in the earlier case also where a similar discharge was there, this honorable court has kept the issue.
We are issuing a notice, but
maintainability open. The notice was issued. But otherwise, my lord,
dissatisfied.
My lord?
We are issuing a notice, but dissatisfied with the medical condition.
The delay, my lord,
Mr. R. Mazumdar, counsel for the petitioner,
one point of time.
as well as Mr. R.K.D. Chaudhary, the DSJ appearing for the respondents. The order dated 30/10/2001. Where is the order?
That order, lordship, will find that page. Yes, at page 24 is the original, page 23 is the type copy.
2001 you are challenging now?
2009, thereafter the promise for the pension, which finally came to be rejected in 2009, my lord. And thereafter, when I corresponded that this is not correct, in 2022, they tell me that no, you will not get anything. In fact, that batch of people, they have been sent back for a remedical examination, and some have been accommodated by the respondents.
Perhaps, lordship, it's too late in the day.
No, that's why I am not satisfied. I am just I'm issuing a notice
Very
that
similar situation, my
It's
lord,
a
if lordship goes
dissatisfied.
to this, the issue of maintainability has been
It's a-
kept open, the delay part.
termination notice dated 30/10/2001 and consequential and subsequent letters dated 15/1/2009 and 15/11/2022 are being sealed by the petitioner, filing this repetition under Article 226 of the Constitution of India. Issue notice returnable in 4 weeks. Requisite extra copies of the repetition be served on the runner DSG in course of the day. Next, list after 4 weeks.
Time being item 18.
The case of dismissal from service.
Compulsory
This is-
retirement.
Sorry, compulsory retirement, my lord. Notice at this point.
Mr. R. Majumdar, counsel for the petitioner, as well as Mr. R.K.D. Chaudhary and DSG appearing for the respondents.
Lordship, I'd just like to point out one thing. If your lordship will come to page 4, respondent number 5. This is not correct, lordship. Perhaps my friend needs to correct it because the impugned order was passed by the commandant. 15 BM SSB. Now commandant sector headquarters.
Commandant sector headquarters has issued it, but he was also functioning as the commandant. If lordship will kindly have page 73, my lord, the impugned order.
It's commandant 15.
Page 74, lordship will find it is Neeraj Chand, commandant, 15th Battalion SSB Kojalgaon, holding the statutory power of commandant SHQ SSB. I was posted at SHQ SSB. So the commandant SHQ SSB has signed the order. He was holding dual charge, 15 Battalion and SHQ.
No, but he's right. He is passing the order as 15th Battalion Commandant. He is holding charge of a senior post.
He is holding the charge of the senior post and he has of the sector headquarters. And he has dismissed me.
This
I was never in 15 Battalion. I never served in 15 Battalion SSB. I was holding a post under the sector headquarters SSB Bongaigaon.
Okay.
Therefore, he has to dismiss me in the power of sector headquarters. If I go for the other argument, then the power would not be there for him to dismiss me, being of a different battalion.
The punishment of compulsory retirement by order dated 31/7/2023 and the dismissal of appeal by order dated 17/11/2023 are assailed by this writ petition filed under Article 226 of the Constitution of India. Petition was sent. Okay, give extra copies. Same date, same.
I'm obliged, madam.
Item 19.
My lord, the director is out of station, so I could not contact him in spite of. And otherwise, my lord, I have gone through the notification, my lord, issued in this regard, my lord. It says that the district commissioner can transfer. But here in this case, he has not transferred, my lord. He can issue the transfer order as per the notification, my lord.
I received the said notification, Lordship.
Hmm?
And I received the said notification, Lordship. And they stated a deputy district commissioner has the power, Lordship,
To
to transfer, Lordship.
But in this case, my lord,
He
he
should
has
have
not
direction to others to do it.
And I talked to the personnel of the office of the director of health service, whether that transfer order has been modified or any or cancelled. So that transfer order, my lord, which has been passed initially by the director, that has not been cancelled or altered or modified. my
So
lord.
we stay the operation then,
Yes, my lord.
otherwise he'll be in difficulty.
Yes, my lord.
Heard, Mr. P.K. Murray, learned counsel for the petitioner, also heard.
I am for response number 1, 2, and 3, my lord.
Mr. D.P. Bora, learned standing counsel for the health department representing respondent numbers 1, 2, and 3. And Mr. A. Chakravarti, learned government advocate appearing for respondent number 4. Next paragraph. The case of the petitioner is that by an order dated 29/2/2024 issued by the Director of Health Services Assam, the petitioner was transferred and posted as pharmacist of Bagan State Dispensary under the establishment of the Joint Director of Health Services, Gwalpara. Stop. On receipt of the transfer order, the in charge Deputy Superintendent of Ambari Bazar, AMBARI, Ambari Bazar Model Hospital, released the petitioner on 2/3/2024 in order to enable him to join his new place of posting. Accordingly, on the same day, the petitioner joined his place of posting at Bhagwan, BAGUAN, Bhagwan State Dispensary as pharmacist on 2/3/2024. Full stop. However, by another order dated 4/3/2024, the Joint Director of Health Services Gwalpara, on verbal instructions of the District Commissioner Gwalpara, cancelled the petitioner's transfer order dated 1/3/2024. In the first line, you write transfer order 29/2/2024, which was issued by memo dated 1/3/2024. Stop. Next, the matter was adjourned for some time to enable the learned standing counsel for the health department to obtain instructions. Full stop. Upon instructions, he has submitted that the initial transfer order was issued by the Director of Health Services Assam, which has not been modified by the competent authority. Just of how it is submitted that the Director of Health Services Assam is out of station, and therefore he could not obtain all the instructions. Next paragraph. Give us this notification. Give us that notification. Just give me the number.
Print out that and send.
Give me the number.
Number, Lordship, on 9 September 2021, Lordship, and then
9 September 21.
ABP
75
ABP dot 75.
dot 75
Please repeat slowly.
to 2021.
Please repeat.
ABP dot 75
ABP
dot 75
dot 75
oblique 2021
2021
oblique 01
01
dated 9/9/2021
issued by
issued by the Government of Assam in the Personnel Department.
Personnel B department,
Personal department.
My lord, it is Personnel
Personal
Department.
department.
personnel department.
Yeah, because the Principal Secretary to the Government of Assam Personnel Department.
Next, be the recipient issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the honored state and departmental council in course of the day. Next, heard all sides on the prayer for interim relief. So, having noted that by virtue of notification number ABP / 75 of the 2021 / 01 dated 9/9/2021 issued by the
List of the four.
Government of Assam to its personal department have authorized the district commissioners to make inter-district transfers but full stop, but comma, in this case in hand, the district commissioner, instead of passing any order of transfer, has directed the Joint Director of Health Services, Gwalior, to stay the transfer order issued by a superior authority, i.e. by the Director of Health Services Assam. Full stop. It prima facie appears to the court that the Joint Director of Health Services, Gwalior, being subordinate to the Director of Health Services Assam, could not have stayed the transfer order of the petitioner to stop. Next, moreover, the hearing before referred notification dated 9/9/2021 empowers the district commissioner to pass a transfer order, but it does not empower the said authority to stay a transfer issued by a competent authority. Full stop. Next, full stop. Accordingly, the court is inclined to stay the order number GDHS oblique establishment ESSTT full stop oblique PHAR oblique trans TRANS oblique 21-22 oblique 373 dated 4/3/2024 issued by the Joint Director of Health Services, Gwalior. Full stop. So the petitioner shall produce a certified copy of this order before the Joint Director of Health Services, Gwalior, within bracket respondent number 3, to bring the order to the notice of the said authority. List after 4 weeks.
Replacement.
24.
May I please address? My lord, I may be permitted to withdraw the petition with the liberty to approach appropriate forum with appropriate. Appropriate forum. With appropriate petition. Liberty be granted.
Item 23.
May it please your lordships. My lord, this is my second repetition, lordships. Lordships, earlier I had approached that husband of the petitioner served as member of Assam State Commission for Protection of Child Rights. Lordships passed the order and lordships directed to comply the order within a period of 3 months by paying the pay and allowances, lordships. Lordships, accordingly, lordships, part payment is paid, lordships. And lordships, this one contempt petition was filed, and subsequently when the respondent filed the affidavit, lordships, thereafter, lordships, that contempt petition is closed, lordships, with a liberty to approach before the honorable court with fresh grievances, lordships. Lordships,
Page 50. Everywhere position. Sorry. Contempt. Contempt. 91, no? 91, my lord, contempt order.
lordships, 92 lordships, 92 lordships, lordships. Order dated 28/8/2023, lordships. Last sentence.
This contempt case is by another person. Petitioner is Rajesh Sharma.
Lordship, there are 3 persons, lordships.
No, that's okay, Mr. Sharma. Here, where is the representation to the state government that what is your entitled, where is your representation seeking from the respondent authorities your correct calculation of salary? Where is that?
Lordships, this we have, lordship, after passing the order by the honorable court, lordships, we have submitted the order, lordships, before the respondent.
No, that is okay. We give a direction that pay the salary. Salary is paid. Now you say that salary was 100 rupees, they calculated at 99 rupees. Correct. Now this 99 rupees and your claim for 100 rupees, where is that before the respondent authorities?
Lordships, these similarly situated persons, they have also approached.
No. You see, we are not concerned with all of this. Because then I would be a busybody, trying to know about affairs of others. I'm not interested there. You say that your salary should have been 100, but you are given calculation at 99 rupees. Accepted. Where is your representative of the government that you pay me 100 rupees? Where is that? Government may make a mistake in making payment. Where is the rules? Where is the rules?
Lordship, page 23, Lordships.
23.
Page 23, Lordships.
Yes, where is the relevant part? Now you have retired.
Lordship, retired. This-
So your
this
entitlement as a
Lord-
retired
this petitioner
member.
Expired, Lordships. This husband of the petitioner expired. Now wife is claiming Lordships.
No, it's okay. But under this rules, where is the retirement dues of a retired person? Where is that?
Lordships, regarding this Lordship, I have to take instruction. Lordships. May 3, matter will be taken upon 5-year Lordships.
27.
Listed after vacation, you make the calculation
Lordships.
on the when did your husband die?
Lordships. Lordship, everything, Lordships, I shall place in the next date fixed. Lordship, everything I shall place in the next date fixed, Lordships.
It is not mentioned when he will die.
Okay. On the prayer made by Mr. R. Sharma and counsel for the petitioner, let's start listen to the motion column after the ensuing vacation. Mr. P.C. Sudhir and additional senior government advocate, and Mr. S.K. Medil and standing counsel for the AG, and Mr. A. Shalia and standing counsel for the finance department are present.
Supply item 56.
Inter.
Just a moment. Acha. Transfer, yes.
The affidavit we have filed, your lordship. I've got the notifications on record as well as the reasons.
Okay. Yes.
Yes, my lord, we have just received the same. Well, some time may be granted to clarify the matter because they have relied upon the 2002 notification, no office memorandum. But in fact, we have relied upon the 2009 and 2013 notification. In 2013 notification, the affidavit filed by them in the page number 56, wherein it has clearly stated that the state government have issued circular from time to time outlining the policies of the transfer and posting of the government officials. This circular inter alia stipulated that transferable officers and staff should normally be transferred only upon completion of the 3 years of service in a particular place of posting, whenever public interest demand. But in the 2002 notification, there is no such stipulation that the staff is also included. Subsequently, in 2013 notification, the staff has been included. That clarification has not been given in the affidavit.
No, because their stand is that you don't, that a member of service of your class is not even covered by that office member, if I remember correctly.
Yes, my lord. In 2002, there is no such stipulation, but in staff, the word staff has been used in the 2013 subsequent office memorandum. That is the latest. After that, that has been annexed by my learned friend also in the affidavit in opposition. And on the other hand, my lord, and on the other hand, my lord, their basic contention is that this transfer has been issued in order to safeguard the revenue interest and place the right officials at the right place. My lord. In that regard, my lord, kindly take up my writ petition, my lord. The impugn order, page 26, my lord. This impugn order has been issued totally non-application of mine, my lord. Kindly see the page 26, the serial number 27, my lord. The serial number 27, Sri Umakanto Lasan, has been transferred and the current place of posting written under one person's name. Next, my lord, kindly serial number 21. The Sri Nore Ingti transferred from Sorupathar to Sorupathar. Then, my lord, 22. This Onimesh Odhikari, Shivam Bonded Warehouse, Dhubri, transferred to Jagirot, my lord. But this person, earlier, in the earlier transfer order, my lord, the page 21.
Yeah, which serial number?
Serial number 21. Sorry, 22. Serial number 22.
Yes.
This person here, they have shown transfer from Shivam Bonded Warehouse, Dhubri to Jagirot. But kindly turn page 23, my lord. Page 23 of the earlier transfer order.
Yes.
Serial number 54. Sri Onimesh Odhikari, earlier already he has transferred from Shivam Bonded Warehouse to Dhubri to Lakhimpur, Gwalpara. Now he is presently working in Lakhimpur. That's why this present person has to be transferred from Lakhimpur, Gwalpara. But again, transferred from the same place. Then, my lord, kindly serial number 12, page 26. Sri Joy Kishan Das, page 26. 26, page 26, serial
Yes.
number 12. Joy Kishan Das, he has transferred from Shubhalakshmi Bonded Warehouse, Tinchukia to Bihali Circle. And this person, my lord, kindly see in the earlier transfer order. Serial number 34, page 22. Page 22. Sri Joy Kishan Das, Shubhalakshmi Bonded Warehouse, Tinchukia to Lakhimpur Sodar. So he ought to have been transferred from Lakhimpur
Yeah,
Sodar.
which serial number? Serial number?
Serial number 34, my lord. Page 22. Shubhalakshmi Bonded Warehouse, Tinchukia to Lakhimpur Sodar. Meaning thereby he ought to has been transferred from the Lakhimpur Sodar. So these anomalies were clearly reflected from the earlier transfer and this transfer order, which clearly shows that totally non-application of mine and whimsically this transfer order has been issued. My lord. It cannot be said that this transfer order has been issued in the interest of public service. The person has already been transferred in another place. They are working in another place. Now again the from earlier place to transfer in another place, and the same and one same place to same place. How is it possible? So these transfer order, as per my information is concerned, my lord, the commissioner has whimsically issued this transfer.
No, there is another reason, Mr. Islam. You're not agitating their cause. Somebody,
Yes, well, just I
somebody
have to
has,
show that the
no, that's
application.
okay. But we don't know don't know about that. Because unless you highlight this, the respondents will not be able to respond to it about the discrepancies. That's one part. But on merit,
That's why,
of,
well, just
but on merit, in case of your transfer order, what do you have to say?
And as per in my transfer order is concerned, my lord, only after 83 days I have been transferred, and specifically there is no such reason, and even my earlier period of service, my lord, there is no such allegation against me that I am not the competent officer and I am not the competent employee, that I cannot do my duty. And the 2013 notification, my lord, which will applicable in my case also, because officers as well as the staff, the two words has clearly mentioned. And now the office memorandum 2013 is holding the field. Though I have been transferred within a period of 83 days, no specific reason they have cited regarding my transfer is concerned. So my humble submission, your lordship, this my transfer is not in accordance with the public interest.
Yes. Yes, Mr. Sakia.
In respect of item 57, madam, may kindly peruse the last transfer order at page 19. Page 19. Madam.
Last transfer order of 6624.
No, my lord, 12 February 2024, my lord. Page 19, my lord.
Yes.
Here, lordship will find my name at page, my lord, 20, serial number 25. I was transferred from Chapormukh Circle to Dhekiyajuli.
Your serial number is?
25, ma'am. I was transferred from Chapormukh Circle to Dhekiyajuli Soritpur. And a private respondent, serial number 28, my lord. Serial number 28, Deep Jyoti Odhikari. He was transferred from Thekiajuli Circle to Hojai. In my place, in place of another person, madam, he was transferred. Thekiajuli Circle to Hojai. Was got it, madam? Page serial number 28.
Yes.
My lord. Next, Lordship will kindly turn to the impugn order, my lord, at page 24. And relevant person is page 25, my lord. Serial number 36, Deepjyoti Odhikari from Hojai to Thekiajuli. Serial number 36, my lord.
Yes.
Deepjyoti Odhikari, that is the private respondent, my lord, from Hojai to Thekiajuli. He has been brought back to his earlier place of posting. And my serial is at page, my lord, serial number 37, Jamaluddin Ahmed, Thekiajuli to Sodia.
Yes.
So, my lord, my transfer has been issued only to accommodate the private respondent in his, my lord, home district. It is not a my lord, transfer issued in public interest. Only to accommodate the private respondent in his home district. After 83 days of his transfer from Thekiajuli, he has been brought back.
How many days?
83 days,
83.
my lord. And as regards the, my lord, violation of policy decision, that is on round of contention, my lord. The other round is, my lord, the policy, the clarification, loss will find clarification given by the personnel department. Page 54 of the affidavit filed by the respondents, my lord. By this office memorandum, page 54, was important, my lord.
Yes.
They have clarified the earlier to, this was issued on 2nd of July 2002. This office memorandum was issued on 2nd of July 2002. So, my lord, by this clarification, they cannot clarify the subsequent office memorandums issued in the year 2009 and 2013. They have
Pardon me, I did not get you. Please repeat again.
my lord.
Please repeat again. I did not get you.
My lord, by this my lord, office memorandum issued on 22nd July 2002, they cannot clarify the future notifications issued in the year 2009 and 2013. Why? This clarification are in respect of, my lord, the notification issued on 4/2/2002 and 25/5/2002. 2002. Not in respect of the office memorandums issued in the year 2009 and 2013.
Yes.
And the 2013 notification, my lord, office memorandum, page 56, is itself is a clarificatory office memorandum, my lord. It itself is a clarification. It says, the state government have issued circulars from time to time outlining the policies of transfer and posting of government officials. These circulars inter alia stipulate that transferable officers and staff should normally be transferred only upon completion of 3 years of service in a particular place of posting. This is a clarification. It's the clarification of the policy of the on transfer issued by the personnel department. So, the staff cannot be segregated from the purview of the policy decisions published by the personnel department, even if they are not gazetted officers. Then, if these office memorandums are applicable in respect to the petitioners also, they cannot be transferred just like that without taking approval from the chief minister. And in the impugn, while issuing the impugn transfer orders, they have not taken any approval from the chief minister.
Makes sense. Yes.
Yes.
So, my humble submission is that the impugn transfer order is not in respect of the present petitioner, is not issued in public interest. It is issued only to accommodate the private respondent in his home district, and it is issued in violation of the policy decision of the government, which cannot be permitted by the Honorable Court within a period of 83 days. This is my humble submission in respect of item number 57. And item number 58, 58, the petitioner herein, is the private respondent in item number 55, 56, 56. In my place, the petitioner in item number 56 has been transferred. Lordship may kindly see, in this case, another office memorandum of the government has been violated, because the petitioner is a government servant and his wife is an employee of a bank. His wife is posted in Guwahati. His kids are studying in Guwahati. And only to facilitate them nearby places, he was earlier transferred to Hazo. Now, by this impugn order, he has been transferred from Hazo to Thokua.
Yes.
Hazo to Thokua. So this is in clear violation of section 4, my lord.
Your serial number is?
My serial number is 39. Page 27, my lord.
Yes.
He has been transferred from Hazo to Guakhana, my lord. This is, my lord, in clear violation of the, apart from the policy decision of 2013, 87 policy decision also will find at page 30.
Page?
Page 30. 30, my lord.
Yes.
This is the policy decision in respect of, my lord, posting a spouses, my lord, in the same station. And the clause which is applicable in respect to the petitioner is, my lord, clause 3, Roman 3, my lord, page 31.
You are referring to which page?
Page 31, my lord.
30.
Page 31. It starts from the office memorandum starts from page 30, and the relevant portion is page 31, my lord, Roman 3. Where one spouse belongs to an all India service, state government service, and the other spouse belong to a public sector undertaking, either of the two may apply to the appropriate cadre controlling authority, and the said authority may post the said officer to the station of the other spouse, or if there is no post in that station, to the nearest station where a post may be available. And the wife loss will find, page 33. Wife of the petitioner is posted at Guwahati. She is working in Canara Bank, my lord. His daughter is studying in my lord class 3, St. Mary's Senior Secondary School, Maligaon, page 38. And his old ailing mother, he's the only son, my lord. His old ailing mother is also suffering from various ailments, my lord, which will be indicated from page 40.
Yes, Mr.
So,
Patel.
my lord, this transfer order has been issued in the middle of the session, my lord. In the middle of the session of the daughter of the petitioner, and in violation of the policy decision of 1987, as well as the 2013 policy decision. It cannot be said to be issued in public interest. It is clearly a whimsical order, my lord. It should not be entered in, it should be said.
Yes,
my lord,
Mr.
by
Patel.
some report, my lord.
Your lordship takes up item number 56. Item number 56, the first item.
56.
Yes, sir. WPC 3023 of 2024.
Yes.
We have filed a affidavit in opposition on two aspects here, lordship. Firstly, on the public interest, which necessitated this transfer, as well as we have, in that affidavit, we have stated, your lordship, if I may read that relevant paragraph, which is at page number 39 of the affidavit, your lordship. That previous transfer of February, your lordship, that process does not have anything to do with the present one. That is clear from this paragraph. Paragraph number 5 at page number 39.
Yes.
That the deponent begs to submit that the assistant inspectors of excise under the excise department of the government of Assam were transferred in the month of February 2024, pursuant to instructions issued by the Election Commission of India on 21/12/2023 and 24/2/2024 in connection with the general elections. In the meantime, new rates of ad valorem levy came into force with effect from 1/4/2024 by Gazette notification dated 7/3/2024. Pursuant to such enhancement of levy, the MRP of liquor in Assam was enhanced by approximately 20%, which led to a wide disparity of prices as compared to neighboring states like Arunachal Pradesh and Meghalaya. As a result, there has been widespread influx of liquor from the said states into Assam, causing a huge loss of revenue. In such circumstances, in order to safeguard the revenue interest and place the right officials at the right post to protect the public interest, a major reshuffle of departmental officers was necessitated, including grade 3 non-gazetted officers such as the petitioner. The impugn order dated 6/6/2024 was issued to address the aforesaid public interest. This is the overwhelming public interest, your lordship, due to which, even though due to the elections, your lordship, since there is a requirement by the Election Commission of India that nobody can be allowed to serve in his home district. So there had to be a reshuffle, not only in the excise department, across all departments of the government of Assam, your lordship. But now, your lordship, because of this new emerging situation regarding the disparity in the liquor prices between Assam and the neighboring states, we have had to do this reshuffle of the officers of the department. Now, regarding the second claim of the petitioners, Your Lordship, that they are covered by those notifications, Your Lordship, the notifications, I have chronologically annexed all of them right from 1992 onwards, the first one. So the first notification Your Lordship will have at page number 48. This is in supersession of all earlier notifications, Your Lordship, on this issue. Government has examined afresh the instructions issued from time to time regarding transfer and postings of government employees. After careful consideration of pros and cons of the matter, the following guidelines are issued anew in this regard, in supersession of all previous guidelines for strict compliance by all concerned. So this is in supersession of all previous guidelines. Transferable officers and members of staff should normally be transferred only upon so Lordship may kindly take note, the word members of staff is also used in this notification of 1992, because that is what the petitioners were trying to project. Transferable officers and members of staff should normally be transferred only upon completion of 3 years of service at one place. Non-transferable staff should normally be transferred on completion of 3 years in one table, but an officer need not necessarily be transferred when he completes 3 years in one station stroke table if the interest of public service does not demand so. Whenever public interest demands that an officer should be transferred from his place of posting even before the completion of 3 years in the place, proper justification of the grounds may be recorded in writing for the transfer, and orders issued only after getting approval of the Chief Minister for such a transfer. So this is the genesis of the requirement, Your Lordship, which mandates that the Chief Minister approval is required for issuing transfer orders before 3 years. Now, this order, Your Lordship, perhaps was not being followed properly, because at page number 51, on 4th February 2002, a second notification was issued. It has reference to this earlier notification also.
Yes.
At page 51, as per state government standing OM number so-and-so dated 19/9/92, the transferable officers and staff, again staff word is used, should normally be transferred only upon completion of 3 years of service at one place. But an officer need not necessarily be transferred when he completes 3 years in one station if the interest of public does not demand so. In the said OM, it has been stipulated that whenever public interest demands that an officer should be transferred from his place of posting, even after completion of 3 years in the place, proper justification and ground may be recorded in writing for the transfer, and orders issued only after getting approval of the Chief Minister for such transfer. However, in practice, it has been observed that such stipulation for taking approval of Chief Minister is not always obtained while making transfer and posting of government officials, for which litigation often takes place. The Honorable Guwahati High Court in its order dated so-and-so, in so-and-so has directed the respondents to comply with this provision as a measure to check arbitrary transfers of government officials before completion of normal tenure of 3 years. It is therefore reiterated that all concerned should strictly adhere to instructions and guidelines issued by its standing government office memorandum quoted above, that is of 1992, and not to violate the provision of the said office memorandums. Now, again, in May of that year, Your Lordship, there is another reminder. It is again a reminder. It says, Government Office Memorandum dated 1992 and 4/2002 clearly laid down the policy of transfer and posting of government officials. Frequent transfer and posting not only leads to avoidable expenditure on so-and-so, but also demoralizes government officials. In order to streamline the system, the following further instructions are issued. Then, Your Lordship, this is in effect, I'll just read it out. Provisions contained in Government Office Memorandum dated so-and-so are to be strictly complied with by all departments and offices. No exception is to be made under any circumstances. The aforesaid Office Memorandum is equally applicable for all officers, staff under various directorates of government departments. It is further noticed that some departments frequently change the transfer orders without any justification. The practice is to be stopped forthwith. Henceforth, modification of any transfer order once issued would require the approval of Honorable Chief Minister Assam, and the modification must be made only on justifiable ground. Henceforth, the concept of transfer season is introduced in consideration of some inevitabilities. The months of December and January would constitute the transfer season. The department directorates would be competent to effect transfers and posting of government officials having completed 3 years only during the transfer season. Any transfer outside the transfer season would require the approval of the Honorable Chief Minister Assam. However, this shall not be applicable to officials being posted or promotion against vacant posts, as well as officials having completed 3 years being moved to fill up a vacancy caused due to death, retirement, etc., or an official being moved out on disciplinary grounds. Now, Lordship, at page 54 is the clarification. This is the vital document. State government has recently issued OM number so-and-so of 4/2002 and OM number so-and-so of 22/5/2002 regarding transfer and postings of government officials and ban on transfer of officials before completion of 3 years in a particular place of posting. It appears that some confusion has arisen regarding its applicability. It is therefore clarified that these circulars are applicable only in respect of gazetted officers whose services are transferable in the interest of public service. Now, Your Lordship, the petitioners in these matters have relied on 2 notifications after that to project that they have a right, enforceable right, to stay at their present place of posting. The first notification is the 12th November 2009, which is at page number 55. I've also annexed that one as well. It starts, Your Lordship, the undersigned is directed to refer to Government Office Memorandums number so-and-so 4/2002 and so-and-so dated 22/5/2002, wherein it was laid down categorically that whenever public an officer be transferred from his place of posting before completion of the normal tenure of 3 years in a particular post/place, proper justification with credible ground must be adduced in writing for such transfer, and order affecting such transfer shall be issued only after securing the approval of the Chief Minister. However, of late, the stipulation of taking the prior approval of the Chief Minister is not always observed while effecting the transfers and posting of government officers before completion of their normal tenure of 3 years in one place. All administrative departments are therefore advised to ensure that no officer is transferred without completing 3 years in a particular place of posting, unless he is on promotion. In case circumstances require a transfer of any officer before 3 years in exigency of public service or for other reasons, the approval of the Honorable Chief Minister should invariably be obtained before such transfer. Now, this, Your Lordship, is in nature of a reminder. It has a direct, Your Lordship, bearing to the Office Memorandums of 4th of February 2022 and 22nd of May 2002, both of which have been clarified later on, saying that they will only be applicable to gazetted officers. Here, Your Lordship, we have made a categorical stand on affidavit that the petitioners are not gazetted officers, and they have not, that is a stand that they have not rebutted. The subsequent notification of 2013, Your Lordship, that notification was issued, Your Lordship, my learned friend is correct, to amend something. But what it amended, Your Lordship, is the normal tenure of service for which a person has to be posted in a particular place, and the number of years before which, if he is transferred, its approval of the Chief Minister has to be taken. The state government has issued circulars from time to time. I'm reading from page 56, Your Lordship. The state government has issued circulars from time to time outlining the policies of transfer and posting of government officials. These circulars inter alia stipulated transferable officers and staff. The word staff was emphasized, Your Lordship, by my colleagues. It was used in the earlier notifications also, Your Lordships, of 2002. That was later clarified, Your Lordship, that it is only applicable to gazetted officers and members of staff. Should normally be transferred only upon completion of 3 years of service in a particular place of posting. Whenever public interest demands that an officer should be transferred from his place of posting before 3 years, proper justification and grounds may be recorded in writing for the transfer, and orders issued only after getting approval of the Chief Minister. Now, this is important, Your Lordship. The government has re-examined the stipulation of obtaining prior approval of the Chief Minister while effecting the transfer and posting of government officers before completion of the normal tenure of 3 years in one place. After careful consideration, it has been decided that henceforth approval of the Chief Minister is to be required to be obtained only for the transfer of any officer who has not completed 2 years in a particular place of posting instead of 3 years. However, the normal tenure of an officer in place of 3 years in a place of posting for 3 years will remain the same. This modifies the corresponding. Lordship will again note this. So this is again has reference to the earlier OMs. This modifies the corresponding provision of the department OMs number so-and-so of 1992, so-and-so dated 4/2/2002 and 12/11/2009. And all these 3 notifications, Your Lordship, they do not have any bearing on the services of non-gazetted officers. And we have specifically stated, your lordship, in affidavit at paragraph number 6, your lordship, of our affidavit at page number 40, that the post of assistant at paragraph number 6, your lordship, that the post of assistant inspector of excise and constable of excise are both non-gazetted posts. Therefore, they are not covered under that notification, your lordship. Lordship, I have a few Supreme Court judgments, if your lordship so desires, if I may place them. Lordship, the first judgment is SC Saxena versus Union of India.
SC Saxena.
Yes, your lordship. I'm handing over two judgments, your lordship. Yes, SC Saxena and Govardhan Lal. In SC Saxena versus Union of India, this is of 2006, 9 SCC 583. At paragraph number 6, your lordship. If I may read out that relevant paragraph. Para 6, your lordship. We have perused the record with the help of the learned counsel and heard the learned counsel very patiently. We find that no case of our interference whatsoever has been made out. In the first place, a government servant cannot disobey a transfer order by not reporting at the place of posting and then go to a court to ventilate his grievances. It is his duty to first report for work where he is transferred and make a representation as to what may be his personal problems. This tendency of not reporting at the place of posting and indulging in litigation needs to be curbed. Then the facts are referred to, your lordship. Then the second judgment, this is 2004 11 SCC 402. This is State of UP versus Govardhan Lal. Paragraph number 7, your lordship. Though, your lordship, my stated position is that these guidelines do not cover the case of the petitioners. Here, the Supreme Court was examining the impact of guidelines on otherwise transferable posts, your lordship. Paragraph number 7 for once, your lordship. It is too late in the day for any government servant to contend that once appointed or posted in a particular place or position, he should continue in such place or position as long as he desires. Transfer of an employee is not only an incident inherent in the terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contra in the law governing or conditions of service. Unless the order of transfer is shown to be an outcome of a mala fide exercise of power or violative of any statutory provision, an act or a rule passed by an authority not competent to do so, an order of transfer cannot likely be interfered with as a matter of course or routine or for any or every type of grievance sought to be made. Even administrative guidelines for regulating transfers or containing transfer policies at best may afford an opportunity to the officer or servant concerned to approach their higher authorities for redress, but cannot have the consequence of depriving or denying the competent authority to transfer a particular officer stroke servant to any place in public interest, and as is found necessitated by exigencies of service, as long as the official status is not affected adversely, and there is no infraction of any career prospects such as seniority, scale of pay, and secured emoluments. This court has often reiterated that the order of transfer made even in transgression of administrative guidelines cannot be interfered with, as they do not confer any legally enforceable rights unless, as noted supra, shown to be vitiated by mala fides or is made in violation of any statutory provision. So they have not alleged mala fides in this petition, your lordship. And these guidelines, your lordship, are not applicable to them, and the posts in which they are presently serving, your lordship, they are transferable posts. So let them join. And if any individuals have specific personal grievances, your lordship, they can always file a representation in terms of SC Saxena, and that the department will consider, your lordship. But to not join and then indulge in litigation, perhaps as the Honorable Apex Court has rightly observed, that should be curbed, your lordship.
But what do you say about this transfer being midterm?
Lordship.
Transfer being a transfer midterm, and the sessions of the schools are.
Yes,
already-
even that order, your lordship, if your lord, that order is that memorandum of 1992, your lordship, which is at page number 48. That refers to, it covers such midterm transfers also.
Yes.
Point number 3 of that memorandum of 1992, 19 September 1992 at page 48. Point number 3, your lordship. Let me read that out. Transfer orders should on normal occasions be effected in such a manner that the academic session of the children of the transferred employee is not disturbed, as far as possible and subject to exigencies of public service, your lordship. So here, your lordship, even in such cases, the public interest, your lordship, has been given paramountcy.
Okay.
Lordship, otherwise, they were under this order, they were supposed to join by 14th, your lordship. But because of the interim orders, they but they the difficulty that we are facing, your lordship, because the entire department was reshuffled. So it was a chain transfer, your lordship, because they are not joining. Now somebody else has been unable. So quite a few of the transfers are held up now, your lordship. So that is one difficulty that we are facing, your lordship.
My lord, in respect of the election commission guideline, my friend says that one person cannot be posted in his home district. One person cannot be posted in his home district in terms of election commission guideline. An earlier transfer was issued that 12/2/2024 transfer order was issued in terms of the election commission guideline. First of all, my lord, if he is not a gazetted officer, election commission guideline is not applicable. Election commission guideline is not applicable on him. Secondly, the petitioner in WBC 3050, I think 58. He was transferred from Guwahati to Hazo.
3050.
Guwahati to Hazo, within the same district. Hazo and Sualkusi. Which is at Sualkusi. He was transferred from Guwahati to Sualkusi in Malata transfer order dated 12/2/2024. So you'll find at page 24 of my petition. Shushanto Devnath. Transferred from Hazo to Sualkusi. Guwahati to Hazo Sualkusi. So within the same district. And in respect of my lord Axis Saxena, my friend has, my lord, relied on a paragraph which in my lord, paragraph 6, he has relied on. Possibly kindly see the background. What is the background of that case? On what circumstances, my lord, honorable expert hold that, my lord, that transfer, normally a person should join in the place of posting first. May I read the background of the case, my lord? Paragraph 2 onwards, my lord, if you lost it, if I'm.
Yes.
The appellant was employed as an upper division clerk in the Intelligence Bureau between 14/2/1989 to 16/2/1989. He remained absent and claimed that he had telephonically conveyed information to the section officer about his inability to attend work on account of illness. By a memorandum dated 16/2/1989, the appellant was considered as being unauthorizedly absent from duty and was extended the courtesy of the said memorandum served by home delivery. As a consequence, the appellant was issued a warning on 2/3/1989, warning him to abstain from taking leave frequently and advising him that he should get over the habit of taking leave frequently in future, because of which his work suffered. He was also warned that otherwise disciplinary action would be taken. As expected, the appellant made a representation against the said warning, but his representation came to be ignored. On 6/7/1989, the appellant was transferred by an order from the headquarters at New Delhi to subsidiary Intelligence Bureau Tezpur. A relieving order was passed on the same day. According to the respondents, the appellant was relieved on the said day. According to the appellant, however, the relieving order was served on him on 28/7/1989. Although the relieving order was treated as being retrospectively effective from 6/7/1989, nothing really turns on this. The appellant attended work on 7/7/1989 and 8/7/1989 and 9/7/1989 were Saturday and Sunday. He applied for earned leave from 10/7/1989 and 11/7/1989. It is the case of the appellant that that he fell ill on 11/7/1989, as a result of which he could not join the office at Tezpur, to which he was transferred. He went on submitting leave applications supported by medical certificates from doctors who were not authorized under the applicable disciplinary rules. For the entire period from 11/7/1989 to 20/11/1990, the appellant remained absent, and his only reply was that he was sick. On 23/11/1990, the appellant was served with a charge sheet alleging unauthorized absence from duty against him for the entire period. He replied to the said charge sheet, and his only defense was that he was sick and therefore he could not report for duty either at Tezpur or at Amritsar, where he had been subsequently transferred. This was the background, my lord. He was unauthorizedly absent for years. The petitioners here in Malad, they have immediately came up before this honorable court, and they have not been released. The person against whom he has been transferred, he has also not been released. So Malad, ratio laid down in excess of Sena is not applicable in the present facts of the cases.
Okay. Consider and pass orders.
Just for a moment, apart from all this, I have already stated in my petition that after joining in the present place of posting at Tokuakhana on 13/3/2024, my twin daughter had already got admitted in Dibrugarh. That is page 34. I have given the admission receipt. They have got admitted and the classes is going on. And on the other hand, my old ailing mother, she is also suffering from a neurological problem. The medical description I have already annexed at page 31.
Which
So these
item?
two aspects also may be taken into
Which
consideration.
item? Which item?
Item 56.
56.
Yes. Page 34. This is the admission receipt. I have joined at Tokuakhana on 13/3/2024. Page 34. Page 34 and 35. The twin daughter. They got admitted on 15/3/2024. And the prescription of my mother, my lord, is at page 31. He advised for MRI and others. And he is the only person, my lord, to look after his old ailing parents, my lord. And on the other hand, my lord, the petitioner also submitted a representation on 8/6/2024, which is at page 29, through the Superintendent of Excise Lakhimpur. But the departmental authorities has not yet been taken any call over that. Page 29. This is the representation already submitted by the petitioner before the authority, my lord, to the Commissioner of Access through the Superintendent of Access, Lakhimpur. So, my lord, by taking into consideration all the facts, my lord, as per the FC section of judgment, my land fate already has been clarified. And in my case, my lord, within a period of 4 years, I have been transferred 3 times. But in earlier, all the occasions I have joined in my transfer. But in this time, due to this reasons, my lord, I have filed this petition. Much obliged. Deeply.
Lordship is reserving orders.
Yes. 59.
Here, my lord, nurse has been transferred at midterm stage. Now passing off this honorable court, my lord, now she has been, my lord, shifted from ICU to another department. She is working, my lord, perfectly. There is any now problem with the authority concern or with that nurse. Now, lordship, second issue is that, my lord, on last day I have raised a issue that so far the competency of the author of the impugn order is concerned, my lord. But there is a notification says, my lord, this has to be done inter-district transfer that has to be effected by the deputy commissioner, my lord. My lord, it is a matter of challenge, my lord. Let them put the instruction, my lord. Better to file affidavit because they are two or three.
Which document?
My lord, I am placing, my lord. We would also like to put it in a way of affidavit, my lord. And their instruction also are required to be, my lord, placed better to in a way of affidavit, my lord, so that we can come to know that what is the reason of my midterm transfer, my lord.
Lordship,
Otherwise, there is any problem now, my lord, she is doing, my lord, job comfortably.
Lordship, we have the instructions. If Lordship would like to go through paragraph 3 once the entire incident has been mentioned regarding. If Lordship may just have a look. Paragraph 3, it has been stated, the conduct of the petitioner and the inquiry report has also been.
Your inquiry is wrong.
Lordship.
If this is your inquiry report, then your, the finding and the report is otherwise. The conclusion is contrary to evidence.
Lordship, here, Lordship, they have done an inquiry where they have,
No, but whether, you see, with the summary of the statement,
Lordship.
what you should have done is you should have transferred the other person. You are penalizing the petitioner.
Lordship, here, Lordship, as per the narration of the authorities, Lordship, there was a complaint, Lordship, there was an inquiry. In the inquiry, there was not
No, but
enough.
this is serious. We'll we'll ask the court to take up suo motu PIL if this is the attitude of your staff there. He disconnects oxygen of a patient and you say it's nothing.
Yes,
If your administration allows this, then we are converting this. We'll request the PIL committee to look into it and register it as a PIL.
Very serious challenge. No, Lordship, here, regarding the, we are.
No, but this is something which is shocking to the conscience of the court.
Lordship, here, what had happened was there was a complaint, Lordship. As per-
No, you forget everything. But
Sure, I
here
cannot go
there is a definite finding that the oxygen was removed
Yes, my lord.
of a seriously ill patient.
Lordship, I cannot, I have,
We'll ask today itself we'll register it as a PIL.
Lordship, will allow me to just go through the instruction once.
No,
Lordship?
definitely you have produced it.
Yes,
I'm
Lordship, this is-
reading what you have
this is-
produced.
No, Lordship,
the
this is what
only-
we won't.
The only difficulty is I can read very fast.
My lord, if oxygen remove, my lord, kindly see the thread, what
Yeah,
happens, my
Mr.
lord.
Das,
A person is
give
playing
to
with
him.
the, my lord, life of a person, my lord. And I have
He
been
gives, you see, her fiancé has lung cancer. This person makes comment on the fiancé's lung cancer. One of the witness says that. Second witness says that he removed the oxygen of a very terminally ill patient. And then you say your inquiry conclusion is that you officers tried to reconcile and then she refused and therefore you transfer him. If I have cancer and you tell me that you have cancer always if you tell me, will I be very happy with you?
No, Lordship, but the only thing which I'm trying to point, these are her allegations, Lordship.
No, that's okay. But it's your inquiry report. Look at that. It's an inquiry report. And Deputy Commissioner is a party to it. He listens to these complaints. Removal of what you call oxygen of a patient. He is not bothered. He says transfer her. She is a whistleblower then. She'll be entitled to all protection. And we'll ask your authorities if what you call, why this should not be registered as a PIL and then we take it up.
Suppose it happen in other hospitals, my lord.
But Lordship, in my only humble submission is this is the finding of Lordship, but this has not been able to be proved yet, Lordship.
What else proof you require?
Lordship, here there.
You record in your inquiry report. So that means you don't believe the inquiry report. Your Director of Health Services will do an inquiry within 7 days from today. And this issue of removing the mask of a terminal patient will be taken up as a PIL.
Lordship, if that is,
No, we are not bothered.
if that
What is
actually
happening?
happens, Lordship, I'm sorry.
I don't even have a conscience. I don't have a heart.
No, Lordship, if that is the case, Lordship, the rightful person has to, but let me just.
Look at it. You have produced it.
That is something that authorities are
It's
producing.
an established fact, I think what he want to defend, this is a serious allegation. And my lord,
Just a moment, let him say.
he was a part of government, my lord.
Now, see the first witness, what does it say? She's an independent person. She says that yes, the petitioner's fiancé has a lung cancer, and he makes comments on that. And now you want her to compromise. That's why I'm asking me. You see, I have a backache. I have to rise at times early, take a break and come back. Because of long sitting, I feel, at times I have excruciating pain. Now let us say that the members of the bar make fun of me just because I am ill. And the question is, will I be happy or should I be happy? These people who are dealing with it have no conscience like me. They have no feeling, no heart. I don't have a feeling because of the post I am holding. It's not that my conscience doesn't pain me at times, but it is because of the post I am holding that if I have to give somebody what you call a capital punishment, I will have to give it.
Lordship, here, if there has been a gross misconduct by the ailing authority, they asked her to
compromise. Why would she?
Yes.
She is not doing for herself. She is making a complaint about the indecent behavior in the ICU with patients and all about a nurse and nursing staff.
Yes, Lordship.
And then you ask her to be transferred.
No, Lordship, we did not ask her to be transferred as per the instruction, Lordship.
No, you read that. Then last line. I told you I can read very fast. Read the last next page.
The conclusion part.
They all sat in the office of the deputy commissioner, and then deputy commissioner said, transfer her. That's how you transfer her.
Lordship, because initially they did not ask her to be transferred.
Why would she be penalized?
She was
for telling that the ICU in charge is behaving with a patient.
Against the ethics, my lord.
Yes, Lordship, she was asked to stay in that same hospital, but she refused, Lordship, because of which at that
You transfer this man. Your director must make an inquiry and
regarding the conduct of
within 7 days and report back. And we are in respect of that incident, we are registering a suo motu PIL. We won't spare.
Lordship, if that is actually being done, Lordship, yes.
We won't spare.
Better,
These
my
people who think that they can remove mask of a terminally ill patient. If I don't take up a PIL, it will be a bad precedent for the hospital.
Yes,
Lordship, if that has been actually done, Lordship,
This kind of situation.
No, write your submissions, but let me deal with it. Let me deal with it.
Lordship, these were the allegations, Lordship. I have nothing further to say regarding that. If that has been actually done, Lordship, or if
No, please pass it on.
Please.
You filed an affidavit.
Yes, Lordship, if we, on the basis of this instruction, if we can just file the affidavit on the instruction.
No, whatever you choose, like I don't say on the basis of this or whatever, but you file an affidavit.
Regarding the action that we have taken, Lordship, because then it will cover up the entire.
Yes. Heard Mr. S. Chamarial and counsel for the petitioner. Also heard Mr. A. Chalial and standing counsel for the health department. Representing respondent numbers
1, 2, and 3, Lordship.
4 minor will take steps.
1, 2, and 3.
Yes, Lordship, may they have made respondent number 4 as the party, Lordship, who is the main accused, Lordship.
Yes, yes.
In the
The transfer of the petitioner by order dated where is that order?
My lord, page 36, 5/6, 2024. Page 36.
Order number, order and a memo number NS oblique E oblique 438410 oblique 13, page 36, dated
Downside 5/6, 2024.
5
5/6,
6
2024.
2024,
After signature.
by which the petitioner was transferred from 200 bedded civil hospital Goalpara to staff nurse at Jaleswar Model Hospital Goalpara is under challenge in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. By an order dated 18/6/2024, the Learned Standing Counsel for the Health Department sought some time to produce instructions. Full stop. The instructions are produced which will be referred to at a later stage. Next paragraph. In view of the nature of grievance raised in the present writ petition, letter notice of motion returnable on, give a date after 4 weeks, make it 5 weeks, on so and so. Requisite extra copies of the writ petition be served on the learned departmental counsel in the course of the day. Next paragraph, the petitioner shall take steps within 2 days for service of notice on the respondent number 4 by registered post with AD. The learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next, there are heard both sides on the prayer for interim relief. Next paragraph. As indicated above, the learned standing counsel for the health department has produced instructions received by letter dated 21/6/2024. Full stop. It is noted that along with the said letter dated 21/6/2024, a bunch of other documents are also produced, which includes inquiry report by a 5-member inquiry committee, which includes the SDM and HO, it was two, TW, two, SDM and HO, two senior medical and health officer, and one staff nurse. Full stop. The As per the summary of statement recorded, the first witness had stated that the respondent number 4 witness number 1 is the petitioner. We omit her statement for the time being. Save and accept that she has stated that the respondent number 4 is was passing personal remarks regarding her fiance's lung cancer. Stop. The witness number 2 has merely stated that she is aware of the attitude of the respondent number 4 to the sister and patients. But stop. However, she did not see on the spot. So similar statement is made by the witness number 3. Stop. The witness number 4 was also confronted with the rude attitude of the respondent number 4. And who does not allow her to follow the assistant matron's direction. Stop. The witness number 5 has stated that she had seen the respondent number 4 disconnecting the oxygen mask of a seriously ill patient. And she has also stated about inappropriate behavior of the respondent number 4. Stop. Witness number 7 has also expressed concern about unprofessional behavior of the respondent number 4. Stop. The last witness examined was the respondent number 4, who denied any wrongdoings, public misdeeds. Stop. Resultantly, the inquiry committee concluded that the allegations against the respondent number 4 was not supported by any written or audio visual documentary proof, and those incidents were not recent incidents, and it was concluded that all had occurred due to misunderstanding amongst them during remote past, and it was recorded that everything was compromised and accepted by all, and that the reintroduction of old incidents showed mental torture or their personal conflict. Stop. At this stage, the court is not examining the content, the tenability of the inquiry report. Full stop. It is only the observations of one of the witnesses to the inquiry report, where the said witness has noticed that the oxygen mask of a seriously ill patient was removed by the respondent before. This court is of the considered opinion that that particular incident be examined by the PIL committee of this court. And to see if examined by the court and to take an appropriate decision thereon. Next para. Be that as it may, in view of the contents of the inquiry report, the court is of the considered opinion that the transfer of the petitioner expressly appears to be a result of the fact that she had refused to compromise the matter, for which as per the paragraph's comments in respect of para number 3 by the Director of Health Services, Assam, no, sorry, para 11. The at the instance of the District Commissioner Gwalpara and Joint Director of Health Services Gwalpara, had put up the proposal for transfer of the petitioner for an amicable solution. The court is inclined to stay the operation of the impugned transfer order under memo number so and so, page 37. Based on up to date after 5 weeks. 19/8. This you take tomorrow, take back tomorrow. Your paragraphs comments.
Lordship, here, if the district commissioner can also be made a party in this petition, my lord, because he is.
The matter.
This order was passed by the
Yes.
Joint Director.
No, my lord.
Let them interact. Let them interact. Let them interact.
My lord, one observation, if lordship feel it would, because lordship pointed out about to reference to the, my lord, PL committee, my lord. Is it necessary to refer this matter to the PL committee or, my lord?
Not your transfer. Transfer to PIL. No, no.
I can collect tomorrow.
Tomorrow. Because you require it.
So that operations stay of, my lord, in the order.
Say it.
Yes.
item 39 for orders.
It will just a moment, just a moment. It will environmental side.
39.
Yes. Now this is becoming infectious.
Might be lordship, I have lost
Because
communication.
2019, even the otherwise tenure is over. Close it on that ground.
Two nine was a message he moved it on our tour and the pastor eating more down, not to give the amount of faculty or interest power. That is not given.
না যাব একেলগে যাব
He is for 32 years is for continuing this less.
Normal tenure is over, we close it on that ground.
More than 3 years. He is there for 32 years.
No, he must be liked by all. Heard Mr. MP Sharma and counsel for the petitioner. So the present petition was filed by the petitioner to assail the transfer order dated 6/3/2019, by which he was transferred from Dhubri to Golaghat.
No, Golaghat to Dhubri, lordship.
Huh?
Golaghat to Dhubri.
I don't know, in synopsis I'm looking, it's Dhubri. Oh, from Golaghat to Dhubri, okay, from Golaghat to Dhubri. From Golaghat to Dhubri. And this court, while issuing notice of motion by order dated 2/9/2019, had state the transfer order with the direction that the same shall not be given effect to. Full stop. Next, the learned Mr. T.C. Sudhir, learned additional senior government advocate appearing for the respondents, has submitted that a normal tenure posting of a government servant is 3 years in a particular area. And as per instructions received by him, the petitioner has been serving at Golaghat in the office of the District Fishery Development Officer as a fishery demonstrator, has been serving at the same place for about 32 years. Full stop. Next, be that as it may, as the normal 3-year tenure posting of the petitioner is already over, and it is stated by the learned additional senior government advocate that the petitioner has been rendering service in the same place for about 32 years. The court is of the considered opinion that the that with efflux of time and the normal tenure posting of 3 years being over, but this requisition has been rendered infructuous. Full stop. Accordingly, this requisition stands dismissed as having been rendered infructuous. Full stop. The interim order passed on 2/9/2019 stands vacated.
Right.
40,
Appears in call for the petitioner. Petitioner remained unpresent when the matter was previously listed on 10/5/2024. Next, Mr. E. Gant, Leonard, counsel for respondent numbers 4, 5, and 6. And Mr. R. Dhor, Leonard, standing counsel for standing counsel for respondent number 1, 2, and 1, 2, and 3 are present. Is present. Accordingly, it appears that the petitioner is not interested to pursue this matter. Accordingly, this petition stands dismissed, having not been pressed. Dismissed for non-prosecution.
item 42,
My lord, the issue involved in this case is covered, covered by the judgment. My lord, issue is diploma in civil engineering and planning, whether it is equivalent to diploma in civil engineering. Now, this issue was gone into in this case, my lord. The lordship would kindly come to para 14. An additional affidavit filed by the state was referred to, that it is pertinent to mention that in the instant writ petition, respondent PW has already filed an affidavit in opposition, stating inter alia that Public Works Road Department, considering the views of the Director, Technical Education Assam, and with due approval of the Honorable Chief Minister, while later dated, has informed APSC that diploma in civil engineering and planning is equivalent to diploma in civil engineering, with the request to consider the candidates who have acquired the qualification of diploma in civil engineering and planning in the recruitment process for the post of junior engineer civil under Assam PWD pursuant to advertisement dated so and so. So this was the stand of the state. Then if your lordship would kindly come to paragraph, page number 49. 49 would be here. Page 49.
Yes.
The conclusion of the report dated so and so made by the committee constituted on 18/11/23, which has been accepted by the government, state as follows. Based on the above observation, it may be concluded that diploma in civil engineering and planning offered by Polytechnic Girls Polytechnic and diploma in construction technology offered by CIT Kokrajhar are comparable to that of diploma in civil engineering offered by SCTE Assam, State Council for Technical Education. Subject offered for all the three diploma programs are core subjects of civil engineering and useful in discharging duties of PWD Assam as junior engineer. The above averments made by the respondent number 1, that is Government of Assam, in conjunction with the report dated so and so, submitted by the committee, which was constituted on 18/11/23, clearly goes to show that petitioners who have diploma in civil engineering and planning and diploma in construction technology who have submitted their candidature for being considered for the post of civil engineering in pursuance to the advertisement dated would also have to be considered for the said post, as diplomas they possess are equivalent to the diploma in civil engineering. Thus, the petitioners are having the requisite qualification for the post of JE Civil in terms of the advertisement dated so and so. Accordingly, as the controversy regarding the issue whether petitioner could be considered for the post of junior engineer having been decided by the state respondent, the APSC, which is only the selecting and recommending body, would also have to consider the cases of the petitioners for appointment to the post of junior engineer civil in pursuance to the advertisement made so and so, provided they submitted their application for the same and had taken part in the written examination. And my lord, in this case, what had happened, as far as the facts of the present case is concerned, there was an advertisement, then there was a rejection list who didn't have the qualification. Then on 25/11,
Is it relatable to the same advertisement? No.
no,
Different.
no, this is by PWD and instant case is by irrigation. Advertisement is at page 29 of the writ petition. Same issue, whether civil diploma in civil engineering and planning is equivalent to diploma in civil engineering. Page 29 on top. A candidate must have passed 3-year diploma course in concerned engineering discipline from an institute recognized by government, State Council for Technical Education. Diploma obtained through distant mode will not be accepted. Here, in fact, my lord, this is more, favorable to us. There it was specifically said diploma in civil engineering. We had diploma in civil engineering and planning. In fact, this Girls Polytechnic had adopted this only, pursuant to the recommendation of the technical committee. So initially we were selected to appear, then we appeared in the test, then the verification was done, everything was done, my lord. Eventually, a revised list was published. When the names of the petitioners were omitted, our cases were not considered on the plea that diploma in civil engineering and planning, which we possess, is not equivalent to diploma in civil engineering. In fact, my lord, APSC is nobody to question this actually. APSC is a body who is meant to work based on the requisition sent by the government. The government stand is very clear. APSC as an examining body, they have no business to find out who is having what degree.
No, they'll have to see it for the limited purpose of qualification.
For that they can see. But then the issue is already covered, my lord.
Yes, that's different now.
So our cases were not considered on the ground that we are not having the required degree. That's not the position. But yeah, I think my learned friend also appears in one of the case.
My lord, item number 43, item number 43 is also pertaining to the same
subject matter, my lord, wherein, my lord, we have been rejected. I have been rejected on the ground that my civil engineering and planning is not equivalent to civil engineering, my lord. So we have also brought, my lord, similar, my lord, grounds. And my lord, there was one document which we could get in our case, my lord, at page 183, that is between the recruitment process, the APSC confirmed from the Director of Technical Education whether this particular diploma in civil engineering can be held equivalent to civil engineering. So there was a response from the Director of Technical Education saying that it can be considered at par and it can be considered equivalent to that. If your lordship may kindly come to my writ petition. Item 43, my lord.
2022.
Straight away, I'll take my lords to page 183, my lord.
2022.
183 page.
123.
183, my lord. 183, my lord.
Yes.
Have my lord found one? My lord, this is the letter dated 10/3/2022, which was issued in between the recruitment process, and it was addressed to the Secretary APSC from the Director of Technical Education. And the clarifications which was sought, may I read, my lord? With reference to the subject cited above, I have the honor to state that as per AICT notification and Assam Government Office Memorandum mentioned under reference, diploma in civil engineering and planning may be considered as equivalent to diploma in civil engineering, my lord, which is as per nomenclatures of UG and PG undergraduate and postgraduate degrees in engineering technology as shown in the table below. Now, this table is very important, my lord. This is a verbatim extract from the AICT notifications, my lord. They have mentioned therein major disciplines of engineering stroke technology, civil engineering. Now, what are the branches, my lord? Corresponding courses of engineering technology, civil engineering, and the next, my lord, the part is, my lord, relevant appropriate nomenclatures of undergraduate degrees in engineering technology. Your lordship will find all these, my lord, nomenclatures are used interchangeably for civil engineering. Of course, my lord, it depends upon what, my lord, this syllabus is, my lord. Even these syllabuses are also the same. My lord, number one, building and construction technology, civil and rural engineering, and then your lordship will see civil engineering and planning, my lord. Now, these are just interchangeable nomenclatures they are using against, my lord, civil engineering, my lord. So it was fought by the APSC themselves during the process, my lord. So this is my humble submission. My learned senior friend has already submitted, my lord.
I just may point out one thing. If a lordship should kindly take page number 133 capital B of our writ petition. As your lordships got it, my lord. Adoption of qualification experience prescribed by AICT for direct recruitment in engineering and technology. And let's see civil engineering, that is the core branch. And let's see building and construction technology, civil and rural technology, civil engineering and planning. So these are all civil engineering, my lord. So similar, this letter which my learned friend has referred, though we have not annexed, but in the same department. And in fact, APSC sought response from the AICT, I think State Council for Technical Education and state responded. So these are all different branches of the main core subject.
We are also not disputing that diploma in civil engineering and planning and diploma in construction engineering are not the equivalent of civil engineering. We are not disputing that one. The main point issue before the APSC is that the requising department, the irrigation department, has requisition us to fill up that post of civil engineer, civil engineering, which are prescribed qualification that diploma in civil engineering only. So as there was no clarification from the requiring department that equivalent qualification can also be considered by the APSC, we being the selecting agency, we cannot deviate from that norm. This was the issue before the application. In our affidavit opposition lordship, we have clarified in that aspect also that as we have been requisitioned to fill up the post of civil engineer from the diploma in civil engineering only. So we from our own cannot deviate from that qualification. That is why lordship, the case of initially lordship, both with petition acts are a little bit different lordship. In case of Kanchan Hazarika lordship, where my learned senior is appearing, she was initially considered lordship inadvertently, and thereafter her recommendation was recalled, and the revised recommendation list was published where her name was dropped. So this petition has been filed. But in case of the other petition, their candidature has not been considered and not been interviewed also. No. My lord.
But once this court has already
Yes,
determined,
that case lordship,
then
my assumption is that that was in respect of PWD department, and PWD has clarified that diploma in civil engineering and training and construction technology also be accepted. That is why this honorable court has passed the order. But no such stand has been clarified by the irrigation department. In fact, in the last order lordship, this honorable court has directed the irrigation department to file an affidavit clarifying their stand. Subsequently, when we go to the order of this honorable court lordship, to my advocates have been clear.
Yes.
24.
They have not filed.
They have not. But it was a very relevant one. In that case, when order
No,
was passed,
that theory may not be correct. You see, the reason is that there is a judicial pronouncement. There is again a clarification from this technical
Director of Technical Education, my lord.
Director of Technical Education. Now the department cannot take a contradictory stand because you don't have your own assessment of equivalency. No, but you said you are the persons who are requiring this people, engineers you are requiring. So you must be knowing what is your requirement.
Department of Uniform.
Because Mr. Chaudhary,
No, my lord, my humble
the
submission would
difficulty,
be,
you know,
some government in different department, they cannot take a different
no,
stand.
not that. But when it comes to engineering, in 1 week, we have seen in Bihar 3 bridges falling down.
Including a few months back in the Ganga River also.
No, that's
And the
why
same firm is
three bridges.
constructing our bridge also.
Is it?
Yes. Same firm, oh. So at least for first 1 year, I'll not go over that bridge.
No, definitely you will be the first one to go and take snapshots of the
Even
beauty.
if sitting in home, my floor may crawl some, my lord. All written here.
No, but from London Bridge to falling down to this Bihar Bridge falling down, and then you are saying this bridge is also by the same contractor. It's something
I think
very.
recently, 3 bridges have fallen
Not three.
because of the flood. Anyway, it should be in a position to withstand flood also, flurry of flood.
Okay, let me allow this three
Yes, yes.
do read petitions. But Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. D.J. Das, Learned Counsel for the petitioner.
আমার case
In WPC 4182 of 2022, also heard Mr. H. Buragoy, Learned Counsel for the petitioner in WPC 5882 of 2022. Next, we have also heard Mr. N. Upadhyay and standing counsel for the Irrigation Department representing respondent number 1.
One thing.
My lord, may I just point out one?
In this restitution lordship, all the appointment has been made lordship. All appointment pursuant to the recommendation by the APSC has been made lordship.
No, no,
Five posts-
interim order আছে।
Five posts has only 5 posts has been kept vacant lordship. Only 5 posts have been kept vacant lordship. Already appointment has been made lordship.
Five.
And five posts.
But here we have only 3, 2 plus 1.
My lord, may I make a point, my lord?
Just now.
But in respect of that other matter lordship, which lordship has been going to the judgment in PW department, in that case lordship, interview was not held lordship. This is the basic difference.
No, even if it is not held, it has to be held.
Yes.
of course.
No, I am just pointing on that.
Uh-huh.
But if any third party that has already been issued,
No,
they are not will be affected by lordship order, that's why I am pointing on it.
May I just
No,
point out?
because you see, that is something else. What would happen because of the order?
My lord, in our case, there is an interim order to keep one post unreserved and one post C to be kept vacant.
Even in our case also, my lord,
There's an
order
info.
dated 9/9/2022 specifically court has observed that one post of EWS candidate, that is the petitioner, will be kept reserved, my lord. Specifically, it has been mentioned, my lord.
Pair of the both institutions are different. That's why I am
Can I go?
pointing out.
Yeah, it's okay.
Both pair of the both institutions may can taken.
In fact, my lord, these two petitioners, in our case, they were selected by APSC. Please come to page, page
No, no,
111.
He has made that clarification.
Yes,
He
page
is-
111.
No, he is only making the facts correct for the order. He
Yes.
says that you have been selected, but because later on your
Name was dropped.
dropped.
So
Recalled.
because I was dropped because, my lord, my degree, they doubted my
No, that's why he is
efficacy of
admitting
the
it.
degree.
He's admitting it.
Yes.
He is only making a clarification so that in the order it doesn't come
Yes,
incorrect.
factually no inaccuracy.
हाँ. अच्छा, make it two differently. Huh? In the first state petition, Mr. K. N. Chaudhary and the respondents are number 1,
Yes, yeah.
1 and 5 is Irrigation Department represented by Mr. N. Upadhyay, Standing Counsel, and Mr. B.P. Datta, Planet, Standing Counsel for the APC, representing respondent numbers 2 and 3. Or two. Number 3 and 4, you are there. Mrs. P.R. Manso, Planet, Standing Counsel for the Technical Education Department, representing respondent numbers 3 and 4. In the second petition, Mr. H. Buragoy for the petitioner. Irrigation Department is 1, 2, and 3. APSC is Mr. P.P. Datta is for respondent number 4, 5, 6, and 7.
8 and 9 are
And 8 and 9, Mrs. P.R. Manso, Technical Education. The case of the petitioners is that they are holding diploma in civil engineering and planning, which was obtained from the Central, what is it? Central CIT, Central
Girls Polytechnic Institute.
My lord,
CIT. What is it full form? Central
Central,
Institute of Technology.
yes.
From Kokrajhar. This is an organization of central government?
No, my lord, it must be of the state. It's a polytechnic.
No, it's a government of India,
বুঝা নাই, কোনটো করে আছে?
deemed to be university under the
Huh?
Ministry of Education from a government of India.
ইহঁতো নেকি?
স্টেট কাউন্সিল অফ টেকনিক্যাল এডুকেশন ডিপ্লোমা ইঞ্জিনিয়ারিং রবিটা দেখা যোনে পাইছে স্যার এইটো আপোনাৰ এআই কৰে এখন মানে
আমারও এনেকুৱা ছিল
No, no, the website says so.
ও আচ্ছা আচ্ছা
হ্যাঁ।
আচ্ছা।
হ্যাঁ।
এই যে,
The petitioners
গভর্নমেন্ট অফ ইন্ডিয়া থেকে
SCITE,
huh?
SCITE, State Council for Technical Education. Page 24 of the writ petition.
No, you said that you got it from CIT. You said CIT.
Oh. Huh? Petitioner two. My lord, petitioner number 1, para 2 by State Council for Technical Education, page 5 and 6. Oh, I'm sorry, CIT to নাম তো নেই। Page 5 and 6 of the writ petition.
Just a minute.
Sir, we are PPSC Girls Polytechnic Guwahati under SCET approved for the sir. We are not CIT. Which are you?
In 5182, my lord, there are two petitioners. First
State
petitioner,
Council for Technical, no.
Yes.
second petitioner is from PCPS Polytechnic, Bamuni Madam, Guwahati.
Okay, petition number 1 was awarded Diploma in Civil Engineering Planning by certificate number 011601 dated 5/3/2016, issued by the State Council for Technical Education upon passing out 3-year diploma course in civil engineering planning in May 2011 from PCPS Girls Polytechnic, Bamuni Vedan. So the petitioner number 2 in WBC
Situation to
5182 of 2022
Situation is under SCM.
was awarded Diploma in Civil Engineering and Planning by certificate number 027280 dated 15/9/2015, issued by the State Council for Technical Education in passing 3-year diploma course in Civil Engineering and Planning in May 2015 from the same PCPS Girls Polytechnic, Bamuni Vedan. First of the petitioner in WBC 5882 of 2022 had also obtained a diploma in civil engineering within bracket civil engineering and planning from Girls Polytechnic, Bamuni Vedan, Guwahati.
Annexure 2, my lord, page 55 is the certificate.
Thank you.
My lord, the page 55 is this certificate.
Okay. Next paragraph. The case of the petitioners is that by an office memorandum dated 13/7/2017 issued by the higher education within bracket technical bracket police department, comma, the diploma of civil engineering and planning is considered equivalent to civil engineering by virtue of adoption of qualification experience prescribed by AICTE for direct recruitment in engineering and technology. Full stop. It is also projected that by a letter number SCTE-08 of the 2022 only 157 dated 10/3/2022. The Directorate of Technical Education Assam had issued a clarificatory letter to the Secretary, APSC, informing the said authority that as per Assam Government OM dated 13/7/2017, diploma in civil engineering and planning may be considered as equivalent to diploma in civil engineering. Full stop. Accordingly, it is submitted that the case of the petitioners is squarely covered by the law laid down by this court in the case of Mofidul Islam Khandakar, MOFIDUL Islam Khandakar, KHANDAKAR, and others versus State of Assam and others, WPC 2064 of 2023, decided on 26/2/2024. It was submitted that by the said judgment, this court had observed as follows. Para 15 to 19, you can quote it. Also quote Paragraph. Two and three. Next paragraph. The Learned Standing Council for the APSC has submitted that the APSC is merely a an organization which conducted the recruitment process on as per the requirement of the requisitioning authority, which is the irrigation department in this of the state. First off, it is submitted that as per the requirement of the irrigation department, the as per the recruitment advertisement dated advertisement number 6 of 2020 dated 19/8/2020, the qualification, the educational qualification as prescribed was as follows. Page 29, like. First off, it is submitted that the facts of the present case is distinguishable from the facts of the case of Mofidul Islam Khandakar within bracket Supra, on the ground that in the said case, the requiring authority was the recruitment authority?
PWD.
Was PWD, who had issued a clarification to the APSC for the in respect of the equivalency of the diploma with the civil engineering, and therefore the APSC had accepted the said stand of the PWD, and resultantly the such judgment was delivered by this court. Stop. It is submitted that in the present case in hand, this court, by order dated 22/5/2024, had issued a direction upon the irrigation department to file an affidavit by placing their stand in the present case on record. First of all, it is submitted that the said stand has not yet been taken by the irrigation department, and therefore, as per requisition made, the APSC has to go by the education qualification which was set forth by the irrigation department. First, it is also submitted that there's a distinguishing feature between the two writ petitions which are being heard. So it is submitted that in WPC 5182 of 2022, the APSC had initially declared the results of the petitioners. However, as because of the lack of requisite qualification, the recommendation was withdrawn. First off, it is submitted that in connection with WPC 5882 of 2022, comma, the petitioner therein has not called for interview. Viva or interview, what do you call?
Was on the basis of screening test first, he was not considered. No. Recognition.
No, you are saying that
No interview was conducted in this.
he was not selected.
My lord will kindly come to page 111 of my writ petition.
No, your writ petition he is considering.
Yes.
It is his writ petition. He says that he was not, he did not
Participate in the interview.
his name was not read in the examination and therefore no interview.
My lord, my lord, candidates after the screening test were, my lord, to declare the results, my lord, it was listed in the name of the list, my lord, the enlisted candidates. My name was there, and then they again came up with a revised list, which is the verbatim case with my learned senior. But from where is my learned friend saying from interview, my lord, there was no interview conducted. There was no interview carried. It was only a screening test. I have qualified in the screening test. I was waiting for my result. Only in my RTI, my lord, reply, they have said that your case was rejected because it is not, my lord, equivalent. So it is not the case that I was not called for interview. I was also in the same list, my lord. Then a revised list came up, my lord, which my learned friend is saying.
Yes, sir. There was no, I apologize, sir. It was my mistake. No interview was conducted here. On the basis of the marks, the screening phase, that the candidates were called for document verification. And during the process of document verification, his candidates was rejected due to non-requisite qualification.
Same situation.
Same situation, my lord. Same.
But in case of PWD candidate lordship, there was an interview. In case of earlier case lordship, in case of PWD lordship, there was an interview. But here,
yes, of course.
no, on the basis of mark, figured in a screening test.
In paragraph number 17, I have made a categorical statement. If a lordship wants to peruse, my lord. Yes, my lord. I'm obliged, my lord.
Before months, PPC, taken on writing. Not interview.
my lord.
My lord. Yes, at page 29. 29. Huh? Post is page 28, junior engineer, within brackets, civil, mechanical, electrical.
We are only concerned with civil.
We are concerned with civil.
Only civil. Unconstitutional declared by
Disqualification to Exactly. Government means that. Okay, fine. Yes, sir.
Screening test.
This is already also recommended, sent to the government lottery and appointment has been made.
Screening test malware is correct. From the screening test malware.
From the already screening test of her.
Where we were successful, Miller.
Lordship, on the basis of mark that made this as a prepared lordship.
Millard cutoff was only 33.5, na?
For EWS for candidate.
So different.
Different.
Right.
No result.
No result. If based on the mark,
If they selected,
if we selected,
their name may be recommended.
Exactly, my lord.
Yes.
Correct, my lord. Correct. Screening test malware. Correct.
I pushed the Lordship, page number 122, I would like to point out one thing. Lordship.
আপনি সিম্পলিফাই করে দেবেন আপনার
Okay, got it.
আপনার রিজার্ভ ক্যাটাগরি লেখা
One to no page number.
আর আমার কানে কইছে পাস
Lordship, this is the revised result, Lordship. Here, Lordship, against 290 push, already 290 recommendation has been made from the APSC.
then you will face contempt
Against 290 advertised push, 290 recommendation has already been made, Lordship. If the petitioner is accommodated, somebody has to.
they will face contempt sir नहीं कोई बात
So then what is the meaning of keeping 5 posts vacant?
हां they will face
After
contempt
this
my lord
recommendation order was passed. Government. Yes, Lordship.
correct my lord correct my lord not coming to play correct my lord
I think, my lord, since 5 posts were directed to be kept vacant, so they will have to do it.
Push, the push has to be identified.
no
No, that is basically for the,
Among nine.
yes, yes. No, what I am saying is, my lord. No, correct. No, I'm not, no, absolutely correct, my lord. Only question is, there is a clear order to keep, at least we do not know 5, at least in my case 2.
In
In
our
case
case,
of the
one.
petitioner there is 1. So 3 posts are definitely there. So against those, we should be appointed.
and against each category my lord
Hmm.
in my category EWS women there is a specific order of this court even before they declare the result even in my seniors case also my lord,
Okay, my
the
lord,
same.
it is for the government to take a call. The APSC's duty ends the moment they send the select list.
Order dated 9/9/2022 my lord আপনার order of আমার entry mode.
Our interim order is, in the interim, is directed not to fill up 1 open category post of junior engineer, female, and 1 SC category, female. Our order is dated 10/8/22.
Then. Recommendation is the.
State কথাবিলাক কিয় কৈ থাকে? তেওঁ কাম হ'ল ৰেকমেণ্ড কৰা, তাৰপিছত যি হয় গভৰ্ণমেণ্টে কৰিব। তোমালোকে লাগিব কৰিব লাগিব। Like. Multiply by 2, no? 9/9/22 is the order.
And it's continuing my lord yes my lord
In their
in the respective category.
in their respective.
In respective category.
Yes.
Page 122. 23. The first page, like,
In the
5182.
122. Actually, this is the revised. And
Accordingly, the result of the selection process would be published within a period of how much time?
1 month, within 1 month time.
1 month. Within a period of 1 month from the date of service of certified copy of the order in the office of the ATSC.
And one observation.
Huh?
That APSC has already published the 292 against 294 judges. That is the some candidate has to.
last.
No, we are not saying anything because you will declare it. It will be the government who will have to take a call.
Selected, some candidate will have to be out from this list. But
Naturally.
those candidates not before your lordship. They have not been like
No,
particular.
that's why we are not saying anything. We are not saying anything. We are not terminating anybody's appointment. We are saying that you reject. Huh?
That observation lordship may give lordship.
No, what will be the effect will be a different thing altogether. Because there are vacant posts.
No, from our side, lordship, we recommended all 290. These are, the government has kept vacant. Lordship. Government has kept vacant. Lordship. But we have already recommended. And once the select is published, that lordship record be made to the formal limited unless that part has gone unless court interferes.
They will have to face a hit by correct.
It is lordship in my affidavit page 151. I have taken ground.
My lord.
Deep-
Obliged, my lord.
deep level.
Highly obliged.
So issue that revised. Publish. So
Actually, as a
supplementary-
concept,
supplementary-
question. Deeply obliged. Deeply obliged.
Obliged.
Yes, can.
I hope the bar is getting my voice.
Now,
In between, we are not getting, after he did something, then we got.
No, the reason is that this battery had drained out.
Okay.
So therefore, with time, everything goes. So now we are coming back to this. The voice is low and therefore my secretaries can't catch up.
Right.
And if I can't raise my voice right now because I am having what you call,
Cough.
the viral fever and cough. So
Oh.
therefore, last 6 days I am in a bad shape. I just can't raise my voice. Any interim orders are to be passed, please tell the court master will extend those interim orders to the members of the bar. If there are any interim orders to be extended, please tell the court master will do it. Other matters will get adjourned.